All right, good morning, everyone. Sorry for the brief delay, but we do want to convene the Judiciary Committee public hearing for Friday, February 27th, 2026. Any remarks from my co-chair? If not, this is our first substantive public hearing before the Judiciary Committee this year, so I would like to just very briefly review our rules. We have a sign-up list in front of us of folks who signed up to testify before 3 o'clock yesterday. We will call those folks in the order in which they came out in the lottery. When folks come up, we ask you to please make sure the microphone is on and give your testimony. If you've submitted written testimony, please do not come up here and read your written testimony to us. We've got your written testimony. It's in front of us on our laptops. We can pull it up. You're going to run out of time quickly, so just summarize the highlights of your written testimony. There's no need to read it to us. After you're done testifying, or if you hear the bell, we're going to ask you to wrap up, and then we'll open up to the members to questions. In the interest of time, we'll ask the members to please frame your questions as directly and succinctly as you can for the benefit of the other members and also those who are testifying after you. All right, with that, we will start with the Claims Commissioner, Bobby Shea. Oh, and I should also say, when you come up, if you could identify from the outset which bill or resolution you're testifying on, that helps us pull up your testimony as well.
Good morning.
Morning, Mr. Shea.
Everyone can hear me? Yeah. I'm Robert Shea from the Connecticut Claims Commissioner's Office. With us today is our brand new Deputy Commissioner, Tamara Teed, Attorney Tamara Teed in the back row. Thanks for allowing me to speak today. I'm ready for questions, if that's okay with you folks.
Questions, Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Mr. Shea. I congratulate you on hiring Ms. Teeth. I've worked with her at the Department of Labor for a few years, and she's always been very respectful and great to work with.
Oh,
So,
that's great, yeah. We're very fortunate to have her. Thank you,
yes,
Fishbein.
you are. Thank you. I wanted to ask you, looking at the wrongful incarceration award document that you put together for Stewart.
Yes.
You set forth in that document the standard by which you are to determine whether or not a wrongful incarceration award is issued. And can you just tell us what you said in that decision?
I can summarize it and then look back, but I think where we came down on Stewart was Mr. Stewart's conviction was not vacated or reversed, or Mr. Stewart did not receive a pardon. So we concluded that he was not technically eligible for compensation under 54-102 UU, but because the legislature had sent this claim back to us to look at it again, we did look at it, and our office concluded that Mr. Stewart was eligible sort of under a negligence theory.
Okay, but before we get to the crux, you said on page 3 that the operative statute 54-102 UU requires a claimant, their conviction must have been vacated or reversed, one, vacated or reversed, or 2, subject to a pardon by the Connecticut Board of Pardons and Parole. And focusing on the second portion of that, where in the statute does it say, subject to a pardon by the Connecticut Board of Pardons and Parole?
Thank you. I took that from now subdivision G. Any claimant claiming compensation under this section based on a pardon.
Okay.
That's under Public Act 25-57. It's now subdivision, or subsection G.
So you take the position that just because somebody got a pardon, that they are presumed innocent?
Not necessarily.
Okay.
Respectfully.
So what's the
that's-
standard?
Well, we had to apply this, I had to address this issue in 2 claims that are before this committee today. And the way I looked at it was, start with, did the person receive a pardon? And if the answer was yes, then I go back to subsection A3, which defines what grounds consistence with innocence are. And I analyzed whether or not the pardon could have been issued under a ground consistent with innocent, which is defined in subdivision 3 of subsection A.
Okay, I was able to pull up the statute, and I'm looking at G. That's what you referenced, right?
Yes, sir.
And what I'm seeing G as being, any person who is compensated pursuant to this section shall sign a release, so on and so forth. So am I in the wrong place?
Oh, is that in a blue book? I'm looking at
No.
Public Act 2557.
Yeah, the problem is the updating. So I'm
So
gonna go,
the legislature changed.
yeah, we've
Oh,
changed
I
this a
have it
bunch
here.
of times. I'm gonna go to a different source, just, if you can give me a moment. While I'm doing that, the job of the Board of Pardons and Paroles, would you agree with me, is not to, not to establish innocence? Really, the job before the Board of Pardons and Paroles, in my experience, is contrition, I think that's a major part of it. But I don't ever recall a matter before the Board of Pardons and Paroles where they said, you know, we've adjudicated you innocent. You would agree with me on that?
I don't know for sure, but that sounds fair, Representative.
So, and I have, okay, I'm looking at a better source. Any claimant claiming compensation under this section based on a pardon that was granted or a dismissal of the complaint or information that occurred after October 1, 2008 shall file the claim. So that's what you're relying upon.
Yes, sir.
Okay. And you would agree with me that in order to make that determination, you need to take evidence?
Yes, sir.
Okay. So,
Oh, I don't need it.
with regard to the Streeter, well, before we get to Streeter, in Stewart, you determined that it was not eligible, but sua sponte determined that it was appropriate to shift to a negligence standard.
Yes, sir.
And what is perhaps my ignorance, what authority do you have to shift to that based upon this type of a claim?
The reason I did that, sir, is because this claim was pending for quite some time. Our office initially denied the claim, and the legislature sent it back to our office for further review to award, I think I cite the, I think I cite the actual resolution that you passed in this decision. If you give me a moment, I can find that. Oh, yeah, I do have it on top of page 2. On May 6, 2024, the Connecticut General Assembly enacted Resolution 173, which vacated the Claims Commissioner's Office September 21, 2023 decision. The resolution specifically stated that the decision of the Claims Commissioner is vacated. The General Assembly finds that the claimant was wrongfully incarcerated for a period of 30 days, is entitled to compensation award under Section 54-102 UU. So respectfully, what I did was I agreed that Mr. Stewart was wrongfully incarcerated, but not pursuant to that statute.
Okay.
And I wanted to notify, by filing this claim with you, I wanted to notify, out of respect for this committee, that that's how I got this to that decision.
Understood, but it appears that what was before the legislature on May 6th of 2024 was whether or not your prior decision to dismiss, vacate, deny the claim under the statute was appropriate, and we expressly fashioned an order that says the General Assembly finds that the claimant was wrongfully incarcerated for a period of 30 days and is entitled to a compensation award under 54-102 UU. So you chose to then vacate our decision, not do a wrongful incarceration award, shift, I still don't know the authority to do this, to a negligence standard and do your own thing. Am I getting that right?
That's a fair statement, sir, yes.
So what statutory authority do you have to vacate our decision? It's sort of like, you know, we sit as the appellate court for the trial court. You're the trial court, we're the appellate court. So if we shift to that sort of situation, there's been a trial court has issued its decision, it goes up on appeal, the appellate court finds that you were wrong, says what the law actually is, sends back to you to enter an order in conjunction with what the law says. I don't think any trial court in this, at least in this state, would have the temerity to then say, no, I don't care. I could use a lot of other expletives. How do we get here? What's the statutory authority?
Yeah, thank you. So I agreed with the legislature on most of that phrase. The General Assembly finds that the claimant was wrongfully incarcerated for a period of 30 days and is entitled to compensation. I agree with all of that, but I respectfully didn't agree that 54-102 UU applied. And if you go to the last sentence of the resolution, it says the claim is remanded to the Claims Commissioner for hearing to determine the amount of compensation in accordance with the provisions of 54-102 UU. Respectfully, the answer would have been 0, and then I would have had to have sent the claim back up here, again, not awarding Mr. Stewart any award, even though you also told me that you had, and I'm saying this all with great respect, you also told me that he was entitled to compensation, so I sort of split the apple. I will admit that.
So why would the calculation under 54-102 UU be 0?
because respectfully, he did not have his conviction vacated or reversed, and he did not receive a pardon. Those, in my humble opinion, are the three ways that you can trigger eligibility. And none of that happened with respect to Mr. Stewart.
But sit as the trial court once again. Too bad. I mean, the trial court may not like what the appellate court does, right? Too bad. I'm not, and I'm not being flippant about, but that's the process, right?
Fair enough. So you're right. If I could have decided that Mr. Stewart was not entitled to compensation under that statute and sent the claim back up here with a zero award. You're right.
But you don't have that authority.
I understand.
We direct it. So what would be the amount of the compensation award? I understand you are given a level of discretion to flex off of the calculation, which I've said is a problem, and I think you're proving to the legislature that it's a problem. You know, I think once the finding is made, is the calculation, here's a check, go. You know, obviously this discretion is becoming a problem. So what would be the number under the straight calculation?
It would be zero.
Okay, but why would it be zero for 30 days?
Because, respectfully, because Mr. Stewart is not eligible under 54-102 UU.
Okay, but the legislature has said differently. So,
But
I mean,
I didn't want to find eligibility when I don't think the provisions of 54-102 UU apply to Mr. Stewart's claim.
okay, so then, did you ever do that calculation?
I did not, no.
Okay, so let's get to the second part then. What statutory authority do you have to, on your own, sua sponte, shift to a negligence standard in the light of the legislature's directive to you to do something?
Well, I was looking at the 54-102 UU statute. It doesn't, it
Well,
says.
you've already said it doesn't apply.
Right, but it does say we're supposed to make decisions in accordance with Chapter 53, which is the chapter that allows the Claims Commissioner's Office to make determinations based on negligence. That's in subsection B, but that only applies if the person's eligible. So
You have no
that-
statutory authority.
that's fair.
Why are we at this place?
Why did I
Why
follow?
are we, well, I guess that's rhetorical. So let's get to Streeter. That is an award of approximately $6 million, right? Yeah, just to be clear, it's 5,752,78, plus 136,272. So just under 6 million. The 136, for the record, is for education, which is set up as a trust to be used. So it's not a direct award, right? That's how this works?
Yes, sir.
But the 5,752,000 is a check, is a payout.
Yes, sir.
Okay. Now, the facts of Streeter, Mr. Streeter was convicted of murder and sentenced to 25 years. That's a fair summarization of?
I think the sentence was 35 years initially.
Oh, yeah, 35, and then he served 25.
23, I believe.
Okay.
Yes, sir.
Yeah, you said nearly 25. So yeah, 23 is nearly 25. And then he got a pardon.
Yes, sir.
And what, and you made a determination after he got the pardon that that pardon for Mr. Streeter was in line with the statute, in line with the presumption of innocence.
With the grounds consistent with innocence, yes, sir.
And what fact-finding did you engage in with regard to ascertaining, since we already know a pardon is not innocence, grounds consistent with innocence?
The way I looked at it, Representative Fishbein, was Mr. Streeter did serve the 23 years. He applied for pardon with the Board of Pardons and Paroles. He stated on his application that he did not commit this crime. He testified before the Board of Pardons and Paroles that he did not commit this crime. And the Board of Pardons and Paroles did not comment one way or the other regarding the statements in his application or his verbal testimony regarding his claim that he did not commit this crime. And they issued Mr. Streeter a full pardon. So I went through the process in the statute. He did receive a pardon, which potentially triggers eligibility. And then I looked and said, could that pardon under those circumstances be considered grounds consistent with innocence? And because grounds consistent with innocence is defined broadly under subsection A3, with the key terms includes but is not limited to, I respectfully decided that Mr. Streeter was eligible for compensation based upon the events that occurred at the Board of Pardons and Parole. That was strictly the reason for my decision.
Okay, so the answer to my question was, what fact-finding did you do? You did not. You reviewed the record.
I reviewed the record, yes.
We've already established that the standard before the Board of Pardons and Paroles is not innocence.
Well, I don't know that for a fact, but
Okay.
I will take that as a,
Well, I'll tell you
understand.
that I believe the decisions of the Board of Pardons and Paroles expressly say that. Just because you get a pardon doesn't mean you're innocent, so on and so forth.
You may be correct, but I apologize if I'm wrong, but it did not say that with respect to Mr. Streeter's pardon.
And that may be the case.
Okay. And I think I cited Mr. Streeter's pardon, the text of his pardon in this decision.
So, in this case, what is your understanding as to, I mean, did the Board of Pardons go into the facts and circumstances and the evidence of the underlying murder conviction?
They did not. They did not on the hearing, on the record, which I watched.
Yeah, it had to do with contrition. The good things the gentleman had done in prison, so on and so forth, and he's a changed person, and is it fair for this person to serve out the remainder of his years?
True. Mr. Streeter did also state that he did not commit this crime.
I'm going to tell you, 80% of the people behind bars say that. So it doesn't, I mean, the first person to lie to me in my office is my client. I hate to say that. Invariably, you know, you find out things about people. Anyway. So I'm just trying to wrestle with the fact that if the Board of Pardons and Paroles didn't look at the facts, the evidence, and the underlying case, how one can reasonably make a presumption based upon that record that the person didn't commit the murder. How do, can you draw me a line there?
I just want to make sure, I don't know what the Board of Pardons and Parole looks at Representative Fishbein when they set up an application for a hearing. I don't know whether they looked at the record, whether they read the court decisions and things like that, which I did.
Okay.
So it's possible that they did do that, I just don't know.
Was there something in the court decision that led you to believe that the gentleman is innocent?
Well, respectfully, I'm not sure, talk about my authority, and it sounds like sometimes I do step over that. I'm not sure I have the authority to question what a court decides. I was aware of that Mr. Streeter had an appellate court decision after the jury conviction, and he had, I believe, 2 habeas court decisions, which I reviewed.
Yeah, but you're charged with determining, I mean, once the gate is opened by the pardon situation, it is not a closed analysis.
True. I have to determine whether or not there was, the claim was dismissed on grounds of innocence, or grounds consistent with innocence, or grounds citing an act or admission that constitutes malfeasance by the state. So where I came down on Streeter is I had to look at whether or not Mr. Streeter's pardon was a ground consistent with innocence, and I respectfully decided that it was.
Now, the other one, along the lines with the pardon situation, which one is that?
Tejada.
Yeah, Tejada. Can you tell us what you did in that particular case to establish grounds consistent with evidence?
Respectfully, Rep. Fishbein went through the same analysis. Was there a pardon? Yes. And then I watched the pardon hearing, and Mr. Tejada testified that this incident happened, and he believed that he was employing self-defense, and he should not have been convicted of this crime. And that was also stated in his application before the Board of Pardons and Parole. So similarly, I decided that under those circumstances, that was a ground consistent with innocence, and found him to be eligible for compensation under the statute.
Now, in the Tejada case, you issued your decision on February 10 of 2026, correct? Well, I'll tell you that you did. Okay, we don't have to. I'm looking at it.
Yes, yeah.
Yeah.
Okay.
And in that decision, you wrote this decision?
Yes, sir.
Okay. On page 5, you said, importantly, the Claims Commissioner's Office learned during the July 13, 2026 hearing before our office that the Connecticut Board of Pardons and Parole, now, after Mr. Tejada's application and hearing, generally states at the beginning of any pardon hearing something to the effect of, the granting of a pardon is neither a finding of innocence or an exoneration of your crime. Similarly, the granting of a pardon is not an indication that an applicant has been wrongly convicted. So that's what we were just talking about a little while ago.
So,
right?
exactly. I think now the Board of Pardons and Parole is telling applicants that we are not making any determination relating to innocence or grounds consistent with innocence. So people would no longer have an expectation that they might be getting a pardon based on their claims of innocence. That's the way I looked at that.
Okay. You go on to say, now this seems to mean that an applicant applying for a pardon should not expect that he or she could receive a pardon from the board on the grounds consistent with innocence.
I agree with that statement, yes.
Well, it's in your decision.
Yeah, I still
So-
agree. I still agree with it.
So, if the determination of the Board of Pardons and Paroles is not innocence, which I guess we can not only presume what has been codified in their practice, and your decision in the Tejada case is issued with that knowledge in hand, why would you not then say, I've got to take a deeper dive on this?
I understand your questions, because that Mr. Tejada did not know that when he applied for his pardon.
It doesn't matter, though. It's
I
your
understand.
determination.
That's the way I looked at it. That when Mr. Tejada and Mr. Streeter applied for their pardons, there was not a statement from the board stating that we are not making a determination relating to innocence or grounds consistent with innocence.
But isn't the tail wagging the dog? Because then it's almost like presuming that the only reason why these gentlemen filed for a pardon is so they can get a wrongful incarceration award. The two run congruent. They run side by side, but they are distinctly different. It is irrelevant what their knowledge was, what their thought was about the pardon process, and whether or not it would afford them millions of dollars. But I'm just struggling with this. You know, when a judge is in the, I mean, I just argued a case in federal court, and the judge said to us during our briefing schedule, the U.S. Supreme Court may rule on this issue in the interim, and I want you to consider that because I'm going to consider it when I'm doing my decision. You were in hand with this information, and yet running down the field with the presumption of innocence without doing additional fact-finding.
I understand what you're saying, and I agree that is what I did. Respectfully.
I'm concerned about where we are. You know, I think from my side of the aisle, I've been a very active proponent with this process. And maybe I've been too generous. From my perspective, you know, there's one in here also where there's a recanting. From my perspective, this process is to make it easier for individuals that were wrongfully incarcerated by some malfeasance by government to take their liberty away. It's probably one of the worst things that government could ever do to anyone. And fundamentally, I think that those individuals are entitled to compensation. But here, and even with the recanting case, that wasn't government malfeasance. The murder conviction, as far as we know, was a good murder conviction. Just because he got a pardon, which, you know, if you did great things in prison and you're going to be a great member of society, amen. That's what we would have through our system. But to then turn around and give $6 million to the individual is not a system that I support at all. So I know we have bills this session. Hopefully we can maybe make this process more what it was intended for. But I look forward to hearing from the AG on where we are. So, thank you, Mr. Chairman.
Thank you,
Thank you.
Fishbein.
Attorney Shea, I just have a couple follow-up questions based on the dialogue with Representative Fishbein. On the Tejada case, you mentioned that he was convicted. In the decision, it appears, at least in one point, as if he had pled guilty to the underlying crime. Was he convicted, or did he plead guilty?
Thank you, Rep. Staffstrom. I see at the top of page 3 of the decision, I quoted what Mr. Tejada said during his Board of Pardons hearing. He said, he says he pled guilty.
Okay. Do you know, as you sit here, whether he was convicted after trial or whether he pled guilty?
I could look that up and let you know. I don't know for sure, and I don't want to state something incorrect.
I guess the reason I'm asking is, did you take into consideration whether he was convicted or pled guilty?
I did, sir, yes.
Okay. I mean, because to me, it seems like there's a distinction. You know, someone who is convicted, maintains their innocence throughout, you know, that's one thing. But where somebody is, you know, in that situation, I think it's fair to say, you know, there are circumstances in which somebody could, who maintain their innocence throughout, um, could be found to have been wrongfully convicted, and grounds consistent with innocence exist. But where somebody pleads guilty to an underlying crime, unless that guilty plea is unduly coerced, or there's some sort of malfeasance, I find it hard to believe there could be grounds consistent with innocence. There could be malfeasance in getting the guilty plea, but I find it hard to believe there could be grounds consistent with innocence. Do you understand the distinction I'm making?
I understand, and I certainly respect your opinion. I agree.
Okay. So I guess, well, my opinion's really not what's relevant. Your opinion's what's relevant. So what did you base your finding that there were grounds consistent with innocence here on, given the testimony by Mr. Tejada that he pled guilty?
Well, looking at his entire statement, he says, "I pled guilty." I'm not saying that I was guilty. He said he acted in self-defense, so I took that into consideration, Representative Staffstrom.
Okay. On the Streeter case, I noted here at the beginning you conducted 2 days of an evidentiary hearing. Is that right?
Yes, sir.
What sort of testimony was elicited during that 2-day evidentiary hearing?
I'm sorry, I don't remember exactly. There were a lot of people at the hearing, but I think mostly it was, bless you, it was mostly review of the application that Mr. Streeter filed with the Board of Pardons and Parole, and review of the videotape of Mr. Streeter's hearing before the Board of Pardons and Parole. I did not recall taking testimony on what happened in this event back in 1990.
Okay, so that was going to be my question, because at least from the decision, it looks like Mr. Streeter was convicted in May of 1990. I assume the alleged crime occurred sometime prior to that, so
I'm sorry.
1988,
I think the crime
1989.
was May of 90. I might have got that wrong, yeah.
Okay, so whatever it was.
Right.
You did, during the 2-day evidentiary hearing before your office, you didn't take testimony on the facts or circumstances of the alleged crime.
I did not, sir. Or I don't recall doing that. I mean, I could check, and I'll let you know for sure. I'll go back into our records.
Okay. I mean, because I guess where I sit is, you know, I think somebody could receive a pardon and then make a claim that they were wrongfully convicted, but I think it would seem to me there needs to be sort of a second step after the pardon is granted, that the person does have to present evidence at the hearing before you of grounds consistent with evidence above and beyond what is presented at the claims at the pardon level, that they would have to say, look, you know, I was convicted, but I wasn't there that day, or DNA evidence cleared me, or somebody else copped to the crime, you know, whatever that may be. But it would seem that there should be some testimony, some finding of fact before your office of whether grounds consistent with innocence exists or not. So I guess what I'm looking for, is there anything in the record before your office that we can hang our hat on, essentially, to say, yes, the claims commissioner did look at and did make an independent finding of grounds consistent with innocence?
No, sir. So again, just to make this statement, and I have a sense that, and I don't know whether folks from the Board of Pardon and Paroles are talking with the committee, but I don't know whether or not they look at before they decide to issue a full pardon, whether they look at the history of the events and what happened. I don't know. It sounds like from Rep. Fishbein's statements that they may not, that that's not something that they're studying.
Well, I think at least from their testimony, and they're going to testify, but I think what they're asking us to do, it seems like, is to remand these decisions back to you to sort of clarify or to do an evidentiary hearing on what are the grounds consistent with innocence. I don't think they're, at least the way I read their testimony, they're not saying that these two individuals are not necessarily entitled to a wrongful incarceration award. I think what they're saying is just what happened before the Board of Pardons and Paroles is not enough to meet the standard. There needs to be some fact-finding over and above that.
We would be more than happy to do that. We're ready to do hearings and take evidence all the time, sir. So if that's their recommendation, the Claims Commissioner's Office would not oppose that, certainly.
So you wouldn't oppose a
Or,
remand?
I wouldn't, no, I would do what this committee asks us to do, is a
Right.
better way to say it.
So just one final question on this. I'm reading on page 2 of your decision on the Streeter case. There's a reference to an April 6, 2022 public hearing before the Board of Pardons and Paroles. Mr. Streeter stated in part during his verbal testimony, although I'm innocent of that crime, I take full responsibility for all other crimes and other convictions that I have. Do you know whether, I believe Mr. Streeter was sentenced for a term of incarceration of 35 years and then served 20 some odd years of that sentence. Do you know whether that sentence was imposed just based on the murder conviction, or was that sentence imposed to encompass the murder conviction plus the other crimes to which it seems Mr. Streeter is taking responsibility?
I'm pretty sure, but again, Rep. Staff shall confirm it was just for the murder conviction.
Okay. All right, because obviously if he was convicted of certain crimes to which he's not even arguing he was innocent, then the years of service under those crimes would not factor into the wrongful incarceration award.
That's true, and we
correct?
do address that in many of our other claims,
Right.
where some folks have other convictions and they're serving time at the same time, and that's factored into the ultimate award.
Okay, but at least what's before us, I think it's about a $5.9 million award. It's your understanding as you sit here that that $5.9 million award is just based on the murder conviction and not any of
The 23 years, yes, sir.
Okay,
Yep.
thank you, sir, appreciate you.
But I will confirm that,
Okay,
yeah.
appreciate that. Further questions from the committee? Further questions? If not, Mr. Shea, thank you. Look, I know maybe a couple difficult questions today on these, but I just want to say publicly that for years this committee struggled with a backlog at the Claims Commission. We heard complaints about the efficiency of that office, the time it took, and those complaints have gone away. And so regardless of, maybe 2 or 3 decisions here that there may be some questions on from the committee, overall, I commend you on a job well done at the Claims Commission office, sir.
Thank you, Representative, and we do appreciate the support from the legislature, the governor's office, and this committee very much.
Thank you.
Thank you.
All right, we're going to move on to testimony from the Office of the Attorney General. I believe Deputy Attorney General Meskel is here with her team, and so we're going to have them all come up together. And just for the record, Attorney Meskel, if you could just introduce who's with you, please.
Is it on? Yes. Okay. Good morning, Senator Winfield, Representative Sastrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. I think you know me, but my name is Eileen Meskel. I'm the Deputy Attorney General, and with me today from the office is Lisa Maria Procino and David Yale from our office as well. And they're here to just help if we have questions that I can't answer. As you know, our office is required to represent and defend the state in all civil matters, including claims of wrongful incarceration filed with the Office of the Claims Commissioner. Before you are 7 compensation awards, and in all of them, our office provided a defense. While we may not agree with the decisions, with the exceptions of Senate Joint Resolutions 7 and 8, we acknowledge that Commissioner Shea followed the statutory process and cited evidence provided during the evidentiary hearing in support of his decision. For example, in those decisions, the Commissioner relied on new DNA evidence, findings by a habeas court, or statements from a prosecutor. Excuse me. In contrast, Resolutions 7 and 8 do not contain those types of references or comparable evidentiary support. For that reason, we are here to testify because we believe those decisions do not satisfy the standard as established by the legislature. We agree with the initial proposition, I think was discussed earlier, that the statute provides that a pardon may serve as an initial basis for filing a claim. We also agree that the next step under the statute is to determine whether the claimant meets the eligibility requirements of subsection A. So that basically is, that there's grounds of innocence or grounds consistent with innocence, which includes, under the subsection 3 of the statute, but not limited to, a situation in which the conviction was vacated or reversed and there is substantial evidence of innocence, whether the evidence was available at that time or is newly discovered. In Resolutions 7 and 8, the decision found that the claimants met the eligibility criteria because each claimant testified at their respective pardon hearing before the Board of Pardons and Paroles that he was innocent. The Commissioner concluded that because the Board did not directly dispute that testimony on the record at the hearing, their silence equated to acceptance of their testimony of innocence and thus met the grounds consistent with innocence standard. Our concern is that this is not the standard set forth in the wrongful incarceration statute. There is no presumption in 54-102 UU, nor in any of the statutes that govern parole hearings, that a claimant's assertion of innocence is accepted simply because the Board did not rebut it on the record. Established case law in other contexts provides that when a decision does not expressly comment or address specific evidence that was presented to a fact finder, the presumption is only that the evidence was considered by the fact finder, not that it was accepted as true. That principle is even more attenuated here, where the Board of Pardons is not tasked with making a determination of innocence. The pardon statute only requires the Board to issue written decisions with reasons when they reject a pardon. I apologize, I'm going over. Do you allow me to finish?
Yeah, well, so I think we're going to jump into some questions. I'm sure there's several for you. Representative Fishbein, we'll start with.
Thank you, Mr. Chairman. Good morning,
Good morning.
and welcome to the legislature. The Stewart claim, do you, you were here, you heard the exchange, do you take any position with regard to the Stewart claim?
Well, we obviously objected both initially. We objected, we didn't stipulate to a claim. We obviously provided a defense. We didn't believe Mr. Stewart met the statutory criteria. Understand that the legislature remanded it back. I think we took the same position, which would be our position before, and so we don't have a specific position here today for testimony, the same position that we took in both hearings.
So, just because the stuff happens out of our confines, after we remanded to the Claims Commissioner, was there a proceeding at which you did express an objection, or were you outside of the loop? And
Oh, no, I believe there was another hearing after it was remanded back.
okay,
And we did object, that's correct.
okay, and I guess if the court gives you the opportunity, you show up
Right.
and you do your thing, right?
Right.
So I guess I have to question how that comes to be on a remand like that, because there's no, from my perspective, there's no question before the body, right?
Right.
The appellate court has ruled. So that's interesting. The pardon issue, that being lack of evidentiary support, I believe based upon your introductory remarks, you think the process should be more in-depth so that you get to the point of substantial evidence of innocence. Is that your position here today?
That's correct. Our issue with these two particular decisions is that it was simply based on silence, and that each claimant, testified they were innocent. They have different factual, obviously, scenarios, but that Commissioner Shea found that because the board didn't dispute that testimony, that was evidence, right, because it has to be substantial evidence is grounds consistent with innocence, that was evidence that he accepted, that the board accepted by silence. And our concern is, unlike other decisions, and I tried to give you some examples, and I know there was some reference in the testimony to decisions from last year. There was a couple of pardons. But in each of those, which were, by the way, stipulations, they didn't come out after a disputed evidentiary hearing. But in each of those, there was other evidence, right, outside of just the pardon. There was, in one of the cases, the conviction integrity unit, there was a new DNA evidence. I don't recall in the other one what the actual evidence was, but in each of those, there was distinct other evidence. They weren't based solely on a pardon being issued and nothing put on the record at the pardon hearing. And I know they've submitted their own testimony, so they should be able to obviously speak to what they believe. But that's our position. There has to be the second prong, then that has to be met.
I'm going to go back to Stuart in a moment, but other than those three, so HJ3 and I think it's SJ 7 and 8, do you have any information about the others that you think we should take into consideration in our review of those awards?
No, I mean, we objected to all of those at the Claims Commissioner. We provided a defense that we disputed whether those particular factual scenarios amounted to substantial evidence, but understood that that's sort of a judgment call, and that can be disputed between reasonable people. So we don't have anything further to provide on those.
Okay. So the other aspect about Stewart is the shifting away from statute to this negligence theory. Did you have the opportunity through the process to address that? Did you know about it? Sometimes the court will say, I'm thinking of employing this, but I want to hear from counsel. How did
Right.
that happen?
I'll let, do you have the? Steve Barry, who's, we didn't submit to testify, but he is here. It was his case, and if you want to allow him, we can have him come up. He'll know the particulars of what happened at that.
That's fine, as long as he's with your office.
Yes, he's with our office.
Yeah, that's
So
fine. He can
Assistant
come on up.
Attorney General Steve Barry, come on up.
We can pull another chair over too, guys.
We got way too many up here, too.
I know.
So.
I can stand as well.
No, we'll grab you one.
No.
Just before you testify, sir, just state and spell your name so that we've got it right for the record. please.
Assistant Attorney General Stephen Barry. It's Stephen with a V, B-A-R-R-Y.
Thank you.
Good morning still. So I'm looking at this unusual procedural thing where the body finds that the statute does not apply, however, sua sponte is determining that some other standard may apply, and your knowledge of that and perhaps ability to opine on whether or not you thought that was appropriate and what you did?
So the original hearing, before it went to the legislature, there was a stipulation that the UU statute did not apply. Claimant's counsel agreed that that was not an applicable statute to proceed under. So that was the process. The original hearing was under a negligence theory, and respectfully, I personally believe that the commissioner correctly decided it the first time.
Okay,
So that was pointed out in the second hearing, that it never was a UU case at all. It was a negligence case from the get-go.
Okay, I think there was at least 3 hearings actually here, because initially the claim was denied on its face.
The original hearing was, the commissioner denied it, saying essentially, the plaintiff or the claimant had not proven his case. Came up to the legislature, and the legislature sent it back, and we had another hearing after that.
Okay, so I'm just trying to figure, so when the legislature sent it back, I mean, the intent was to employ the statute. Am I hearing that the claimant then stipulated with the AG's office that the statute did not apply?
Correct.
Okay.
At both hearings.
Okay. Can you get us that stipulation?
I'm sorry.
Can you get us that stipulation?
Yes.
I'd like to,
It was on the record, so yes, we can get that.
We can get a
Yeah.
copy.
okay. So, how does that come, it's a unrepresented person who is given essentially the golden ticket by the legislature, and then pre-hearing a stipulation is entered into that's presented at the hearing that says something different. How does that come to be?
I don't know. Claimant was represented by counsel at both.
Oh, he was?
Yes,
Yeah.
both hearings, Mr. Tomasiewicz.
No, I'm talking about, we're talking about Stewart.
That, correct.
Okay. Mr. Tomasiewicz was the attorney?
He was the
Okay.
attorney on both,
Okay, when he said, I didn't, okay.
at both hearings.
So then, so there must have been communication between the AG's office and Attorney Tomasiewicz post-decision by the legislature, which results in the stipulation presented to the Claims Commission, and the stipulation also says we would rather have this done under the negligence standard?
The stipulation was simply that the UU statute didn't apply here.
You know, frankly, that doesn't make sense to me, because if the statute doesn't apply and the statute was before the Claims Commissioner, then Attorney Tomasiewicz is saying to the Claims Commissioner that the number is 0.
And that was the argument of the state.
Okay. I look forward to seeing this stuff. So. Thank you. That's all I had. Thank you, Mr. Chairman.
Further, let me just ask a couple follow-up questions. So on the Tejada case, I had asked the Claims Commissioner a question about whether there was a guilty plea on the underlying conviction. Do you guys know the answer to that question?
He pled guilty. I believe he also testified that he pled guilty at the pardons hearing.
Okay. And on the Streeter case, my question with respect to whether any part of the 35-year sentence was related to his other convictions, do you guys have an answer on that one?
Yes, so based upon the habeas decisions, which cited to the appellate court decision, Mr. Streeter was convicted of a total effective sentence of 35 years, which included a murder charge and carrying a pistol without a permit.
Okay. And he pled to the pistol charge, or he was convicted on the
I believe
pistol
he was
charge?
convicted of both the murder and the carrying a pistol without a permit. but that encompassed the total effective 35 years incarceration.
Okay. Did your office argue that the award should have been reduced by the percentage that was related to the pistol charge?
We did not get into that at the time of the hearing.
And the claims commissioner, I believe his testimony was that or I guess he was unclear as to whether at the evidentiary hearings before his office there was testimony elicited as to the underlying events related to the murder conviction. Were you at those hearings?
I was, and Mr. Shea's recollection is correct, that there wasn't any testimony given as to the underlying criminal conviction. We did watch the pardon hearing, and in a subsequent hearing, one of the former chairpersons was testified remotely, I believe, as to what occurred during the pardon process.
All right. And at least they're going to come up and ask the claims commissioner this, but I mean, it would seem there's a potential to remand this case back to the claims commissioner for an underlying determination of whether there are grounds consistent with the innocence or not. Is that, well, let me ask you this way. What's your office's ask that we do with Senate Joint Resolutions 7 and 8? I mean, are you asking us to deny those awards outright, or are you asking us to remand back?
Well, I think, of course, you know, as lawyers representing the state, we always ask for our alternative relief. I mean, relief obviously would be to deny them, but we also, I mean, we clearly would ask at a minimum that you remand it back and have the statutory process follow, because that's our biggest concern was really focused on these two cases and the fact that that standard, this new standard created by what we believe Commissioner Shea is not appropriate. So at a minimum, we ask that it be remanded back.
Okay. Further questions or comments? Senator Winfield.
Thank you. Good morning. I always have to look at the clock. So I just want to make sure I understand the position of your office in all of this. So you obviously are protecting what the office sees as the interest of the state. And so are you required to oppose all of these cases? Is there a requirement that you do that?
I don't think there's a requirement that we do that, like in any other type of liability situation. You know, last year we were here, we had some that we had stipulated to.
So then there is some reason that motivates the opposition beyond just the fact that you're looking out for the interests of the state.
Yeah, I mean, I think what you're asking me is, you know, do we just oppose for the sake of opposing?
I wouldn't put it that way.
Okay.
But if you
Okay, well, what I'm saying is, in every case, obviously, and this is true of all of our claims, not just wrongful incarceration, but in every case, we assess, and there may be pieces, of course, that we stipulate to, like, you know, a pardon existed, we're not going to object to certain facts that are not disputed. We may disagree about what substantial evidence is, and we may make a calculation based on other reasons why we would do X, Y, or Z. So we may, in a case, may be more focused on the damages than we are about liability, for example. But I'm not sure if I answered your question, but I certainly hope that we look at every case and we settle cases and we obviously go forward and object to cases.
And I'll just say, I take every answer as responsive to my questions, and if they're not, I will.
Okay,
I will make
thank
sure that
you.
you know. So you don't have to guess. I'm not trying to
Yeah.
trick you. So I then assume that for each of these, you look at not just what the claims commissioner did, but the totality of the case, right?
That's correct.
Okay. So help me understand how you view the substantial evidence portion of it.
Well, let me go back. If you're, we obviously, the concern here is about what he based his decision on
Sure.
these two. But, we obviously do look at, we try to, when we are investigating the case, or what's presented and what the claim is, obviously. So, I'm sorry. So what was your question specifically?
Substantial evidence.
Substantial evidence. Well, I mean, that's going to be a very fact determination. But what we've seen, what were in these other cases that were before you, the other, I believe, 5, maybe 4, I forget the actual number, is so, and what has been relied on even previous to this, to my recollection, and Lisa Maria can correct me if I'm wrong, is some type of other evidence, whether it's through the conviction integrity unit. We've seen that in a few of the cases where there's been newer technology and newer DNA testing, or new DNA testing when some was never done. There's habeas granted, statements by the judge. Habeas in of itself isn't always evidence of innocence. It could be some other reason, due process, maybe they retry the case. There could be statements of the prosecutor. We had that in some of these cases. And so, I'm sure we could come up with the easiest case of where, some new person confesses and the DNA points to them, and that's clear evidence, substantial evidence of innocence. Beyond that, I think it becomes, a balance of what the evidence is, and
I'm not asking you to do anything more than what you did.
Yeah.
I will say, there are folks who later have, through DNA, been proven to be innocent, who
Sure.
tried over and over through habeas and were denied and told all kinds of things. So the actual real world value of that, I understand the import of it, but the
Yeah.
real world value of that, particularly given my history here, I struggle with sometimes. I'll be honest, right?
Right.
And I guess I'm just trying to figure out how the office looks at these things, knowing the history behind a lot of this, knowing the history involved in this case with the detectives that were involved in this case, the witnesses that say the detectives said they said things that they did not say, that recanted, all of that, the maintenance of innocence from day one, the history of the inability of folks who clearly had a case because they've later been proven innocent, which doesn't happen in every case, and why the state doesn't value, I don't want to say that, but I think there's a value to the state of making sure that we don't do the things that we've done in the past, right? And so when I asked the question about the position that the state takes to protect the state, I think it's protective of the state that we don't put innocent people in prison, as we make sure that people who didn't deserve to get compensation for having been in prison go to prison. So I'm just trying to figure out in that whole milieu of things what we are doing.
Yeah, I appreciate, it's a difficult balance, right, in terms of what you're trying to achieve and what the statutory requirements are. I do think, though, we're not in the position of the decision maker, right? That is the Office of the Claims Commissioner, and that's the Judiciary Committee so when we look at, we of course look at all the evidence, we have to weigh the pros and cons, but we have other evidence we have to look at. I mean, there were 2 habeas denials in this case. And so the problem with this decision for us is simply that it was based on no evidence there was no evidence presented at the Claims Commissioner, right? It was simply based on a pardon that was issued by the Board of Pardons and Paroles. And that's why we're here. We're not here because we didn't necessarily agree with other decisions, but we understand that the decision maker, we may not have agreed in a particular case. Is that substantial evidence? That's a tricky standard. I'm not going to disagree with you. That's hard.
Your office does get involved before the final decision of the Claims Commissioner, correct?
Well, we get involved, yes.
And you had opposition before the Claims Commissioner's decision, correct?
I'm sorry?
You held opposition prior to the Claims Commissioner's
Oh,
decision,
yeah, well,
correct?
right, we
So
show,
it's not, sorry, I
right.
didn't mean to step on you, go ahead.
Yeah.
You could proceed.
I'm sorry, yes, no, we, depending on what the predisposition statements and what the claim is being made, absolutely, we go in sort of trying to know what the argument's going to be.
Well, that's why I asked you the question about all of the history, right? Because
Right.
I can understand your perspective as it relates to the Claims Commissioner's decision and the Board of Pardons and Parole, but that's not the only reason why you had opposition to this claim. That's why I was asking the other question.
Oh, right, you mean in the underlying proceeding itself, not why we're here today. Right, no, we disputed because of the other underlying, well, I don't actually think that happened at the hearing, because the focus was on the pardon itself. Am I correct
That's
about that?
correct, yeah.
Right, yeah.
Yeah, we didn't reach any of the other evidentiary issues that I think, Senator, you may be referring to at the hearings before the Claims Commissioner. We were focused solely on the pardon and the testimony and evidence related to that proceeding.
Okay, thank you.
You're welcome.
Senator Kissel?
Thank you very much, Chairman Staffstrom. Thank you, folks, for coming to testify. I guess I'm just looking at this from a very narrow perspective. As I see it, and I'm setting aside the amount of the award, which clearly is substantial. And I think that whenever you're talking millions of dollars, of taxpayers' dollars, whether it's justified or unjustified, it catches our attention. But I'm going to set that aside. I have similar concerns as you folks are testifying regarding the standard that Commissioner Shea applied. Sometimes I want him to temper his mercy with a little bit more justice, in my opinion. I know there's that old adage, silence is acquiescence, but I don't think that applies here, because I do view a hearing for a pardon as substantially different than an adversarial proceeding to determine guilt or innocence. And so here we have that he applied his standard in good faith, but it gives me pause. And I agree with you that I think it needs to be remanded for a further hearing based on more substantial evidence if it is going to be ultimately a determination of innocence. Maybe not the same balance that's done in a court of criminal law. It may be more of a balancing test, but I have a real problem when the Board of Pardons and Paroles just doesn't speak up regarding someone's proffer statement that I'm innocent, and that's to be taken to the bank on that issue. I don't think that's appropriate. So that's just me, but that's where I intend to vote later on these two matters. That being said, I'm a little bit still up in the air because there's this notion that if we don't act as a legislature within a certain period of time, things go into automatic, they're automatically granted. And I think that's by like March 26, or certainly there's this element of before the end of March. And I'm wondering if we do send this back for further actions to clarify this issue, if the full legislature does not act on that before the end of March, does it automatically go into effect the way we set it up? Let's assume it does, either because the legislature didn't act prior to the end of March, or let's say that there's some way to dance around that if the legislature doesn't act on it one way or another. And if we find ourselves in that point, and setting aside the value of these awards, what kind of precedent does that set? Because that's where I want to go with this. In other words, worst case scenario for me is we somehow, this standard that I don't think is appropriate nor just to the taxpayers or the individual that's up there, because I think the individual, if they're proffering that they are innocent, that there would be good to have some sort of termination based upon more than just acquiescence through silence. Would that and I'm more familiar when we're looking at like a trial court's determination, and then it goes to the appellate court or Supreme Court, they rule on it, and then we can, stare decisis. We can look at precedent. And that's the whole common law, right? We're always looking back, where were the lines drawn? And because we're in this sort of world that I am not as familiar with, where we're bouncing between the Claims Commissioner and Board of Pardons and Paroles and and the legislature, what kind of precedent would this set if it goes into effect based upon the analysis and the determination that the Claims Commissioner had in these two matters. What's the downside? Can someone just trot out now next year and say, hey, and let's say the Board of Pardons and Paroles just doesn't say anything again. Is that like a magic wand and all of a sudden that person's innocent too? Because I think that we all can look at whether it's presidential pardons or pardons that affect people here in the state of Connecticut more locally. That hearing is based upon things that the person did, showing that they've remediated themselves, they're going to be law-abiding, upstanding citizen. It's a whole different analysis in my book to get a pardon, and sometimes there's no analysis, whether it's Republican or Democratic administrations. Usually it's at the end. President Trump's doing it like in the middle of his term, but typically it's like the last month of a term, whether it's President Biden, President Clinton, President Obama, President Bush. Slews of pardons come flying out of the White House, and I'd be hard-pressed to say all those people are really innocent. I think that's just the nature of the power that's given to the executive branch that has heretofore been used primarily at the last couple of months of any administration. So where are we going to find ourselves if we can't flip this around and send it back for further determination?
So I'm always love when I get a new legal question that I haven't researched, Senator Kissel. I don't know the answer to the statutory question, which we're happy, by the way, we're always happy to look at that in terms of the March deadline and what the if the whole legislature needed to vote. Let me, and this is just off the top of my head, let me talk a little bit about the presidential. Again, haven't done that research for the legislature. I think it's safe to say in the history, I've been with the office, I think you know, a really long time, that there have been claims, I'm not talking wrongful incarceration claims per se, claims that we defended vigorously that maybe it may have been dismissed and overturned when they came to the legislature. And for whatever reasons those were. And, you know, we probably, in some of those anyway, felt that, you know, that wasn't the correct standard or maybe didn't comply with the statute. And I don't think it created necessarily a presidential effect going forward. We have sometimes one-offs. We do have this doctrine of, you know, you can't just give an award to somebody if they then, or give permission to sue. You know, there's the claim, now I'm forgetting the name of it. But in any event, happens with age. And so I don't think there's case law, but I don't know that for sure, that binds. The biggest issue in terms of precedential value is being fair to all claimants, right? And so I appreciate what you're saying, and which is why we're here really we chose just these two, more not because of them personally or anything related to their factual backgrounds. It was more because of that, this standard that's not in statute. It's not in the board statute. I think they've submitted testimony, which I think was, I want to give them kudos for. I thought was really, really great and well done. That I think they've taken some steps in response to some of this, which I don't think was necessary, but understood why they did it. So I don't know how that will happen going forward. So I would hope, but that is kind of why we're here. We don't want this to be, we want everybody to be on the same playing field, which is to have to present that evidence and bring it forward, because it can be small or it can be big, you know, it obviously varies, but it's all important. And we try to, I think everyone here, between the legislature, our office, Commissioner Shea, the claimants, you know, we're all trying to balance all of those factors.
There we go. I appreciate your response, although I have to be honest, you haven't given me as much ammunition as I was hoping. Because let's say I go to the leadership of the Senate or the House, although I'm a member of the minority, I can get meetings, and they may ask that, what's the big deal? Especially if there's no written in stone precedent similar to precedent of a Supreme Court decision being handed down or something similar. And especially if policies and procedures change going forward in response to what took place in entities outside of the legislature, because ultimately we do our best in this committee, but we're part of a greater body, and sometimes deadlines, for whatever reason, aren't addressed, and things just go into effect automatically,
Yeah.
whether I agree with it or not, whether we as a whole, as a committee, agree with it or not. And so I'm not hearing that there's a end of the world kind of scenario if we don't act in a timely fashion to send this back, but I agree on principle that that would be the most just determination, at least from my perspective, on this committee.
Yeah.
And so I appreciate your answers, and I appreciate the fact that you brought to our attention that, yeah, you may not agree with any of these decisions, but you're focused in on this one for this particular reason. And I think you're on solid ground regarding that. Where it goes, I don't know. Thank you, Chairman Stafford.
Further questions or comments from the committee? Further questions, Representative Fishbein, briefly for the second time?
Yes, briefly. You know, I think it's interesting to learn here today that an appointee of the Lamont administration is taking the position that a pardon without any additional information is akin to innocence, which puts us in a place that one could draw the line that John Rowland was innocent, that the J6 people are innocent, but that's the determination of his appointee. Just wanted to opine on it. We don't want this process to devolve into the AG's office having to prove guilt, because that's what this would devolve into. If the claims commissioner is not going to do their due diligence with regard to innocence, and the claimant is not going to be pressed as to their innocence, then the AG's office is placed in the inevitable position of having to relitigate the underlying conviction. And that is not to the benefit of the public. The other aspect of this, and I share Senator Winfield's concerns about the adversarial nature or the positions perhaps taken by the AG's office, but there's another aspect to this. You know, subsection C of the statute allows discretion for the claims commissioner to deviate from the award and to give even more money than the calculation.
Correct.
So that is, and I think the way the process is set up, every claimant can present evidence to that effect. So you walk into the room not with just, is there innocence, but we have the calculation and now we're going to perhaps litigate this other stuff. So naturally it becomes a litigated matter, and you know, I thank you for standing up for the taxpayers, for the state, you know, in this process. So I just, you know, a lot of people don't know about this process, right? And I think what we've discussed here today has shed more light on what's going on. So thank you, Mr. Chairman.
Thank you. Further questions or comments? If not, we appreciate you guys being with us today. Thank you very much.
Thank you.
Terrence Gamble is next. Online, maybe? Okay.
Good morning.
Good morning, sir. Go ahead.
First, I'd like to thank you all for allowing me to speak on this platform. I'm gonna read from my phone just to make sure I don't get sidetracked. I don't waste you guys' time or anything of that nature. I am kind of fighting a little flu right now, but I felt it was very important for me to step on this forum and speak. My name is Terrence Gamble II. I am the nephew of the late Terrence Gamble. I was born a year after my uncle was murdered, and my family chose to name me in his honor. I've always taken pride in carrying his name and doing my best to uphold the legacy with integrity. Growing up, I heard nothing but great things about my uncle, things about his character, his presence, and the love he had for his family. I have also been blessed to witness the extraordinary strength of my grandmother. For decades, she found solace in knowing that the person responsible for taking her son's life has been brought to justice. Rather than allowing the tragedy to fill her heart with hatred, she chose forgiveness. She devoted years to serving her community and spent decades participating in prison ministry through her church. While she may have encountered Mr. Streeter during her ministry work, never once did she suggest, as he claims, that he was innocent of my uncle's murder. Her forgiveness was an act of faith and grace, not an endorsement of his innocence. It is deeply disheartening to see such a sacred act of forgiveness now being portrayed in support of a claim that contradicts the findings of multiple courts. It is painful that my grandmother must relive this tragedy nearly 4 decades later. At a time when she should be surrounded by peace and family, she is instead forced to revisit one of the darkest moments of her life. That is not only heartbreaking, it is profoundly unfair. As someone who holds a bachelor's degree in criminal justice, I have studied the complexities of the legal system, including wrongful conviction claims. While I recognize that wrongful convictions do occur and deserve serious attention, substantial financial awards of this magnitude are rare and typically supported by overwhelming new evidence. In this case, it is difficult to ignore the timing and circumstances surrounding this claim. For example, one of the primary witnesses who identified Mr. Streeter, had known him for over 20 years and provided detailed testimony, including description of his clothing and the vehicle he was driving the night of his heinous crime. It is also important to note that Mr. Streeter was denied release on 3 separate habeas corpus petitions. Multiple courts have reviewed and rejected his claims of innocence. I am one to believe in our justice system, not because it is perfect, but because it is designed to evaluate evidence thoroughly and deliberately. I also believe in rehabilitation and second chances. However, I do not believe that technical gray areas, such as a pardon or recharacterization of long settled facts, should result in millions of taxpayer dollars being awarded in a case where innocence has repeatedly been rejected by the courts. I wish Mr. Streeter well in his life moving forward, but I stand firmly in opposition to any financial award in this matter. Thank you for your time and your consideration.
Thank you, sir. Representative Fishbein.
Thank you, Mr. Chairman. Thank you, Mr. Gamble, for coming here today. You know, what you had to say, I don't think I could say any better. So it's not often that people come here and tell us about their family situation from a victim side.
Sir.
A lot of people up here forget that there are victims and victims' families. So
Yes, sir.
I thank you for taking your time out of your day. I'm sure your day is important, and you know, thank you very much. So thank you, Mr. Chairman.
Thank you. Further questions or comments? If not, Mr. Gamble, I want to thank you as well for being with us, for giving voice for your grandmother. I appreciate you. Appreciate being with us, and good luck getting over that flu. Seems like there's a lot of it going around right now. So.
Yes, sir. Thank you all for your time.
Lisa DeLulo. DeLulo.
Good morning. Can you hear me?
Yes, ma'am. Go ahead.
Okay, thank you. Thank you, first of all, for the opportunity to come today. My name is Lisa Bull DeLulo, and I'm speaking today in my capacity as a private citizen only. I live in Milford, Connecticut. I'm a retired federal law enforcement officer. I served 23 years in the FBI from 1983 to 2006. I was married to New Haven Police Detective Anthony DeLulo from 1995 until his death in 2000. Before we married, I worked alongside him on a joint federal New Haven Police Department task force beginning in 1991. I came forward voluntarily in this matter. After reading about Mr. Streeter's case and other wrongful convictions connected to Detective DeLulo and others, I recognized that things I had personally witnessed without context at the time during my time with Detective DeLulo seemed to be part of a larger pattern of misconduct, the same misconduct that put Mr. Streeter in prison for 23 years for a crime I believe he did not commit. In January 2024, I gave sworn deposition testimony under TUI regulations in Morant versus the City of New Haven, a federal civil rights case brought by Stefan Morant, another individual who, like Mr. Streeter, was wrongfully convicted in a case investigated by Detectives DeLulo, Joseph Green, and others in the New Haven Police Department, and subsequently pardoned and received a compensation award from the Claims Commissioner. In my sworn deposition, I testified under oath about incidents I personally witnessed involving Detective DeLulo during the early 1990s that are consistent with a pattern of witness intimidation and coercion described by the witnesses in Mr. Streeter's case. I am willing for that deposition testimony to be made part of the record of this proceeding if the committee wishes. What I'd like the committee to understand is this: the misconduct that led to Mr. Streeter's wrongful conviction was not an isolated incident. I was not surprised when I learned the details of what they allegedly did to witnesses in Mr. Streeter's case, threatening them, pressuring them, following them, because it was consistent with what I personally observed during my time working alongside and married to Detective DeLulo. Based on my experience, he developed tunnel vision in his investigation. He withheld information that did not support the result he wanted, and he would say whatever suited him. The Claims Commissioner has already found Mr. Streeter eligible and awarded compensation. I respectfully ask this committee to approve Senate Resolution Number 7. Thank you.
Thank you. Mrs. DeLu, let me ask, did you provide either this deposition transcript or live testimony to the Board of Pardons and Paroles or the Claims Commissioner in this matter?
I did not provide the testimony. I do not have the deposition. I can give you the name of the attorney who conducted that deposition and contact information. I
No,
did
that-
not provide it either to Pardons, the Board of Pardons. I was never asked to, and the deposition, I think, occurred after the pardon hearing, but I'm not positive.
Okay, no, that's fine. I guess what I was just trying to figure out is whether your testimony had been considered sort of either at the pardon level or at the Claims Commission level, and it sounds like it was not because, not any fault of yours, but you just weren't, you weren't involved in either of those processes. Is that right?
Correct. I attended one Claims Commission meeting, but I did not speak. I was not asked to speak.
Okay. And you were never cross-examined by the Attorney General's office or anything else with respect to this case, were you?
No.
Okay, all right. Further questions or comments? If not, we appreciate you being with us this morning to provide this information to us. It's helpful. Thank you very much.
Thank you.
Next up will be Jennifer Zaccagnino, the Chair of the Board of Pardons and Paroles.
Good morning. I'm Jennifer Zaccagnini, Chairperson for the Board of Pardons and Paroles, and I have with me our Legislative and Administrative Advisor, Attorney Colin Milne. Okay. We're here to speak on Senate Joint Resolution 7 and 8. The board does not question the seriousness of wrongful convictions, nor does the board take a position on whether the claimants were wrongfully incarcerated or whether the award amounts are appropriate. Our concern is narrow but significant. To my knowledge and in my 18 years of experience, the board has not granted pardons based on actual innocence. And in these two matters, the board unequivocally states that it did not grant pardon based on actual innocence. The pardon hearing record reflects what the board considered in granting these individuals pardons. The panel, as it always does, focused on the applicant's rehabilitation, education, community service, and contributions since their convictions. Panel members commended both individuals for their post-conviction activity. Mr. Streeter made meaningful contributions to his community after release, and for his part, Mr. Tejada demonstrated substantial personal and professional growth, including graduating from a highly respected law school. These are the type of factors the board routinely evaluates when deciding whether clemency is appropriate. Pardons reflect findings about rehabilitation and character, not a determination of innocence. The Claims Commissioner treated the board's silence as an implicit acceptance of innocence, even though affidavits and board testimony indicated that it does not decide innocence in pardon proceedings. The decisions do not explain why that testimony was not credited, nor does the decision explain why it chose to disregard actual statements from panel members. For example, former board chair Carlton Giles commended Mr. Streeter's progress and acknowledged the importance of the family of the victim's voice, noting that their willingness to speak and extend forgiveness for what he did reflected a great deal of grace and something others can learn from. To support his decision, the Claims Commissioner relied on contract law principles. However, a pardon hearing is nothing like a contract negotiation. The pardon applicant is not making an offer. The board does not bargain. The board exercises a discretionary act of grace. For all of the above reasons, this committee may wish to remand back to the Claims Commissioner. Thank you.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Chairman Zaccanini, good to see you again. It's been a number of years. And please tell Member Carlton Giles I said hi. So not only, it's interesting, all the differing testimonies. So the way the Claims Commissioner put it forward was that the board didn't respond or didn't contravene or didn't speak up, however we want to characterize it, when Mr. Streeter asserted his innocence. And what you just stated, I believe, was that there was ample matters or positions put on the record throughout this entire procedure where the Claims Commissioner could have drawn a completely opposite inference that, no, the Board of Pardons and Paroles, first of all, there's this issue of, this isn't what we're looking at. We're looking at rehabilitation. Should you be granted a pardon, which is totally, to my view, separate from the incidents and the examination and the criminal trial as to guilt or innocence in the initial assessment. This is all post that. And so it's two different worlds in my opinion. But even if we leave that issue aside, that what you're stating here is that you disagree with the characterization of the Claims Commissioner, who I want to be on the record as agreeing with Chairman Staffstrom that he's done a fabulous job, probably the best Claims Commissioner in 30 years I've ever seen. But on this particular matter, that for whatever reason, not only did he draw an incorrect inference, but that there was ample evidence put on the record by members of the Board of Pardons and Paroles where the Claims Commissioner could have inferred that no, the issue of guilt or innocence is not being acquiesced to or agreed to by the Board of Pardons and Paroles. Would that be accurate?
That is correct. I actually testified in one of the hearings, and I stated all of those things on the record.
Thank you very much, Mr. Chair.
Further questions or comments, Senator Winfield?
So I unfortunately was out of room, so missed part of this. But I know that the question of innocence as it relates to what happens with the board is part of the conversation here. It's my understanding that there was a conversation about innocence, at least as it relates to former Chairman Giles. Can you talk about that a little bit?
So I listened to the hearing several times in preparation for today, and while the claims were made by the applicants, there was no discussion.
Because my understanding is that at some point he was under oath that said that the question of innocence was a part of the decision to grant. You're not aware of that?
I'm not aware of that, no. And do you want to speak, Attorney Milne?
You can, yeah, just identify yourself.
I think there are two actual affidavits that former Chair Carlton Giles did file with the Claims Commissioner. Mm-hmm. One was and I believe it was submitted with one of the attorney's public testimony that you may have in your possession. There was a second affidavit filed by Mr. Giles, where he admitted that he had reviewed the actual hearing and then clarified that his position was it was not based on actual innocence.
But the original said it was.
Right, and then there was a second after he clarified his own intention. So there are two competing affidavits.
Okay. And I've interacted with both in this capacity and in other capacities. I struggle a little bit with the question of innocence not being part of your procedures, quite frankly, because I know many people who I've helped through that process who struggled to move forward because they had maintained that they were innocent. But the board, at least for a significant portion of the time that I was working on helping folks, wanted not just what Rep. Fishbein talked about when he was talking about contrition, which is all of the good works that people did, but actual contrition from folks. Actually to admit that they had some role in whatever that crime was. And so I struggle to understand how a board can maintain that they don't deal with the question of innocence or guilt, when in fact that is dealing with the question of innocence or guilt. And many of the people who I have dealt with have felt like they were between a rock and a hard place because they needed that pardon because of the way that the board was functioning. So can you talk to that a little bit? Because I think, I just don't know how the board can say that they don't deal with that question.
Yeah, so I can tell you that the reason we don't hold it against someone is because we have no way of evaluating. We're not equipped to evaluate whether someone is innocent or guilty. In fact, in over half of our pardon applications, we have no police report or transcript, so what would we rely on? Records are destroyed after 10 years, and many of these cases are old, so we are really functioning on what they've done post-conviction.
There's a difference between your ability to actually know something and using the fact that someone won't say that they are responsible or guilty or whatever the case is to keep them from getting a pardon. And I don't think it would shock anybody who's dealt with this process to have heard that that has happened. And I don't think you would, I won't put words in your mouth, but I think anybody who's dealt with this process knows that has happened. And so that is dealing with the question. Is it not?
I mean, we don't deny, if you're implying that we deny if someone doesn't say they're guilty, we just work under the assumption that everyone is guilty because they've been convicted and served their time. That doesn't matter to us. We're more focused, especially in pardons, on their rehabilitation, how they've grown since.
But a person who's not guilty, who goes through your process, is being assumed guilty, correct?
Well, I have
So
no
then
way
the
of knowing, so yeah, if they've done time and been convicted.
So you're not just looking at what they've done, whether they are guilty or not. You're looking at what they've done, assuming they're guilty.
Well, I don't take a position either way. That we don't hold it against them, and
With
we don't
with all due
credit
respect,
them.
I think you just told me you take a position, that you make an assumption that they are guilty. I think you just said that.
Well, they've been convicted by a court of law, so we work with what we have. We have no way of determining their innocence. We granted 1,400 pardons last year, many of whom said they were innocent. We didn't
Again,
deny them.
I'm not suggesting that you have to agree that they're innocent, but there's a difference between whether you agree that people are innocent and whether you enter the conversation assuming they're guilty, right? I think trying to figure out who is in front of you, regardless, the person in front of you, the person in front of you is the person in front of you,
Right.
whether they were innocent or guilty, right? I think assuming they're guilty has a value in those hearings. At least in my experience, it has had a lot of value in those hearings, which is why we try to get folks to operate in certain ways. Is that not correct?
Well, we recognize that people change. We're the Board of Pardons and Paroles. It's our job to pardon people, to parole people. So we look at where people stand today, not at the past when they were younger.
I guess I'll leave it. But I'm having a hard time sitting with that, because if we're looking at where they stand today, but at least for some period of time, I don't know exactly what you're doing today because I don't any longer do that stuff. Mm-hmm. But at least for a period of time, I don't think that was the case. I think it was, at this point, you did this thing, so therefore you have to talk about your perspective on that, where you are on that thing, even when the person was maintaining their innocence up until that point. And so I don't think that's just about where they are today. But I'll leave that there.
Representative Fishbein.
Well, thank you, Mr. Chairman. I wasn't going to say anything. I thought your presentation was fine. We do create policy up here. I don't disagree with the position that you've taken, quite frankly. You have to enter the process. The record is the record. There is a conviction. Through clean slate, I think that's limited it's reduced the amount of matters that come before you, and really the more egregious matters, I think, is the way we've structured it, would be ripe for a pardon. Contrition is part of the process, and I've been, not in a while, not since you've been there, but I've been before the Board of Pardons, and, discussing with my client in a few cases, just didn't want to relive the living situation they were going through, the desperation that led to their crime. I had to have that discussion because I didn't know what I was going to get before the board, but it wasn't healthy for the client. And ultimately, the issue was, are they a better person? Are they entitled to take use of that second chance that our state provides? I mean, one of the cases I had was a young man who lit a trailer park on fire. He was a young man. I think he was 19 at the time. He was 38 at the time that we were doing the pardon. There's no use in going back and having to go through that and all of that. It's a long period of time in between. So I've learned, I'm glad we had this exchange today, because I've learned and that's where I come from. So thank you, Mr. Chairman.
Thank you. Mr. Zacchini, let me just ask, so let me step out of these two cases for a second here, because I think one of the questions I have is sort of what should the process here be, and what should it look like going forward, and how does the wrongful incarceration statute interplay with the pardon process? And I guess one of the fears I have is that if the wrongful incarceration process becomes one where sort of a pardon is at least in strong indicia that a wrongful incarceration award should be granted, or if the Board of Pardons and Paroles doesn't affirmatively say we're not finding innocence but we're granting a pardon anyway, that could have a chilling effect on the pardon process, I think, is my biggest fear. I mean, as you said, I think there was 1,400 pardons. It's no surprise that at least a majority of this committee has been strong proponents of clean slate and second chances and expanding the pardon process. And if anything, I think some of us have been critical of the Board of Pardons and Paroles for not going far enough on certain things. And so I guess what I'm worried about is sort of a second guess or a members of the Board of Pardons and Paroles kind of looking over their shoulder and saying, gee, I would grant this pardon, but I don't want that to be used sort of for a floodgate of wrongful incarceration payments being made. I mean, is that a legitimate fear of mine? Do you want to comment on that?
Yeah, no, I have similar concerns that if we set this precedent, that board members may think they have to deny anyone who claims they're innocent, and of course we don't want that. I think it would change our process, especially if we had to, if we were tasked with trying to determine innocence, oftentimes the cases are old, we couldn't possibly go back and review all of the documents that were used during the court proceedings. So yeah, I share your concerns, Representative
Right, because
Stavstrom.
it seems to me like, and I'm not trying to put words in your mouth, but it seems to me like what you said on maybe the Streeter case in particular is the board didn't care whether he was innocent or not innocent. They believe he deserved a pardon.
That's right.
Irrespective of guilt or innocence of the underlying charges.
Correct. He had done a lot with his community and church, and we felt he was deserving for those reasons.
Thank you. Further questions or comments? Representative Fazzino, did you have?
Thank you, Mr. Chair. Yes, just a couple brief questions. Thank you for being with us, Chair Zaccanini. Appreciate you and your testimony. So you had mentioned previously that you have about 1,400 folks who come before the Board of Pardons and Paroles, many of whom claim their innocence to the board. How do board members typically respond to those claims in the moment?
We don't address them. We focus on rehabilitative efforts, education, community service.
Is there ever a situation where a board member would deem it appropriate to respond to an assertion of innocence one way or another?
I suppose there could be a situation, maybe if we have victims testifying, but it would not weigh heavily in our decision.
Okay. One thing that I just noticed in both the Tejada and the Schroeder decision was this, the note of the disclaimer that the board has implemented following both decisions. I was wondering if you could just speak to why the board has decided to include that disclaimer, what the effect of that disclaimer is, why put it in now?
Sure, I can speak to that. So as a board member, I spent 15 years doing pardon hearings, and when I became the chair almost 3 years ago, I had been working under the assumption that it was a given, that everyone knew we didn't determine innocence as a pardon board. And when I discovered that our intent was in question, maybe a year or two ago, I decided to add the language to make it clear to all.
Has there, were there any other situations like this where, I guess, yeah, so I guess in your mind, is it sort of clarifying what the practice has always been of the
Yes.
BOPP and not sort of, we had this different standard prior to the disclaimer and now we're operating on this new standard that's reflected in the disclaimer language?
It's nothing new. I was just clarifying
Okay.
for all.
Thank you. Thank you for your testimony.
Further questions or comments? If not, thanks for being with us.
Thank you.
Barry Horowitz.
Honorable committee members, my name is Attorney Barry Horowitz. I've been practicing state planning law in Connecticut for the last 40 years. I'm here to oppose the act concerning adoption of the Uniform Real Property Transfer on Death Act. That's raised bill number 5266. This informal procedure contemplated is very controversial. It avoids the protection of the probate courts without even the formality of a trust agreement or a conveyancing form with normal deed formalities. To date, after 16 years of debate, only 20 states have enacted it. The committee's considered it many times over the last 10 years and has not moved it forward. Last year, the Insurance and Real Estate Committee of the legislature also considered it and not moved it forward. The specific problems that I would like to focus on today with the act are as follows. Number one, capacity. It's required to make a will, which is a lower standard than other forms of conveyancing, lower than applies to deeds. Yet this transfer is by deed and is without the protection of will formalities or probate court review. Secondly, not following the wishes of the transferor if a transferee dies. When a transferee dies, the transferor normally wants that transferee's interest to pass to their children That's not what this act does. It would leave it to a co-transferee, thereby disinheriting the children of the transferee who passed. The use of pre-printed forms without even deed formalities or attorney involvement makes it far too easy for an aggressive heir, caregiver, or fraudster to pressure an elder to transfer the property upon death to them without the transfer being witnessed. Claims of undue influence by an heir or caregiver are already very common. Fraud in real estate transactions have been well documented in the media. This act has the potential of making such claims much more common, as happened in other states, and may just be a make-work bill for litigation attorneys. Confusion with nursing home protection. Clients already confuse probate avoidance with nursing home protection all the time. Many will execute these deeds using these forms and believe they have nursing home protection without the benefit of an attorney being present to correct them. Also, we don't need it. In Connecticut, we already have life estate deeds, power of appointment deeds, intervivus trust, joint tenancy deeds. These provide for real estate transfers without the need to go through the probate process. These procedures work well, and they've been time-tested. Conveyancing by non-attorneys. Much more than most states, Connecticut has always taken the position that attorneys should be involved in the conveyancing of real estate, not title insurance companies or non-attorneys, and not lay people with pre-printed forms. The internet is already replete bemoaning the enactment of these deeds in other states and the problems they've caused. Problems with title insurance, problems with clients getting divorced, conflicts with anti-nuptials, incorrect deeds executed by lay people, claims of incompetency and fraud, children of a deceased child being unintentionally
Attorney
disinherited,
Howard,
and most importantly, undue influence,
Attorney
pressure,
Horowitz,
threats, and intimidation.
if
perpetrated
you
upon the
could
elder.
summarize.
For all these reasons, I don't believe this bill should go forward. It's not gone forward in the last 10 years. I don't believe at this point it should go forward either.
Thank you so much. Are there comments or questions from members of the committee? Comments or questions? Seeing none, thank you very much for joining us and providing us with your
Thank you,
testimony.
Senator Winfield.
Nicole Gamble. Nicole Gamble. After Nicole is Stacy Sobel, followed by Maceo Streeter. Stacy Sobel? We can come back to them. Okay, we're going to jump to Maceo Troy Streeter. And if we get that situation.
Hi, they just had me come in. Is that okay?
Is that Stacy Sobel?
This is Stacy Sobel.
Okay. You may testify, and Mr. Streeter, prepare yourself.
Okay, thank you so much. I guess it's technically good afternoon, members of the committee. I'm Stacy Sobel. I'm the Regional Director for ADL, the Anti-Defamation League here in Connecticut. And I'm pleased to be here to testify in support of SB 90, which would consolidate Connecticut's hate crimes laws. As a member of the Governor's Hate Crimes Advisory Council, I was pleased to provide feedback last session, and I would welcome the opportunity to share our perspective with the committee in further detail. We appreciate the ongoing work to consolidate, and we also see this as an opportunity to update our laws and bring them in line with best practices from other states. That said, there is no question that hate crimes deserve priority attention in Connecticut, and the law enforcement must readily have available all necessary tools to address them. These crimes have a profound impact because the targeted individuals they've been targeted based on protected, immutable characteristics, components of one's identity that cannot be changed. I have come to understand this deep impact both professionally and unfortunately personally as well. A couple of years ago, after delivering a Zoom presentation titled The State of Hate in Connecticut, I received a threatening postcard at my home that contained the handwritten statement, "Is there a child rape, torture, and murder tunnel under your home? We have Zyklon B, gas. Use the code Gas the Jews for 10% off." The reverse side of the postcard displayed a photo of Anne Frank at Auschwitz concentration camp with the quote, "We're having fun here." Fortunately, ADL Center on Extremism was able to provide law enforcement with information about the perpetrator, and with the support of ADL and law enforcement, I took steps to ensure my safety. No one should have to experience what I and my family faced. Crimes rooted in anti-Semitism and all forms of hate must be taken seriously and prosecuted under a clear and consistent legal framework so the justice system works efficiently and effectively to hold offenders accountable. Thank you very much, and we encourage your support of this important consolidation.
Thank you very much
Oh,
for your
sorry.
testimony, and sorry for that experience. That's terrible. Is there a comment or question from members of the committee? Comment or question from members of the committee? Seeing none, I want to thank you again for joining us today to provide us with your testimony.
Thank you very much. I'm sorry I was off video. I didn't realize.
We now have Nicole Gamble, I believe, ready to go. So we're going to go to Nicole Gamble and then to Mr. Streeter.
Good morning. Thank you for having me. I have my mom here as well because she's not too fond with the computer system as for me too. I just want to say I have a couple of questions. My nephew spoke everything up what I was basically going to ask. In this case, my question is, how is my brother, if he's awarded this money, how is my brother murder justified where he has no evidence proving that he's innocent? And we just want closure in the matter. And with all this going on, we had to read about it through social media that opened up a room for all of us, and mainly my mom, because my mom's been going through it for years. I was only in the 5th grade when my brother got taken from me, so I didn't have a voice then, but I have a voice now. And I'm confused about the justice system. Even though I know it's civil, it's a criminal matter what he did too. It's not a civil matter what he did. It was a criminal matter. So how do the state justify anything of saying that this money is well deserved to him? When we put our faith in the jury system to uphold you guys, not saying you, but the law to do their job as first and foremost. So who fails my brother? Who answer to my mother? My mother's a victim. Who stand up for the victims in these matters when you guys pay these people this money? How do they reach out to the victims to say, well, this is what happened? None of the families have closure to anything. And I'm gonna give the floor to my mother here because I can't talk.
Yes, I'm the mother of Terrence Gamble.
Ma'am, could you just tell us what your name is?
Joyce Gamble. Sorry.
Okay.
And good morning.
Good morning.
I'm here. It's so much that I've heard. But yes, I forgave Troy Streeter because I didn't want no hatred in my heart. I didn't want no bitterness in my heart. I wanted to let everything go and forgive him. But for him to play on my forgiveness, that's wrongdoing right there. And for him to say it's wrongful for what he was did in the court system, it's not. It's wrong because he know what he was partakers of. And whatever you partakers of, that's the consequences that you're going to have to deal with. So my thing is, how is it going to, I'm not saying that he's asking for this so much $1 million and for the wrongdoing that he did. And he is, to me, my son is gone. I will never see him again. But I can see his face and still walk past him and still go on about my business. But I want to give me some understanding and closures. And this will be for other parents that have lost their sons and daughters. And things have been granted for people for them not knowing. So please help me. And whatever this is me, he don't deserve that money. That's me. So whatever y'all decision is, and I hope it be for the right reasons and understanding how people feel. All right, thank you, and I thank each and every one of you members for hearing me what I got to say.
Thank you, ma'am. some of your questions, it's just not possible to answer right now. The only thing I will say is that this is something that the committee and this legislature struggles with a lot. And unfortunately, some of the ways we've functioned in the past mean that we have to struggle with these questions, whether one believes that someone is innocent or not. We do know that there are folks who've been in our system who are actually innocent, who've been accused of some very heinous things, and people who are the family members who survive thought that they had gotten justice, and because of the way we function, they didn't actually get justice. And so this is the tough job that we have here to figure out which way to proceed. I want you to know that we take very seriously both the claim of Mr. Streeter and the things that you and your family have told us today. Thank you for joining us.
Thank you.
Next, we'll hear from Mr. Streeter. I'm sorry, Representative Fishbein.
I just wanted to say thank you, ma'am, for coming here today. You know, you're speaking for your son, who can't speak because he's gone. And I recognize that. You know, just to
Yes.
elaborate a little bit on what the chairman had to say, it was a few years ago, we decided as a legislature to try and correct some wrongs of the past. Because we recognize that some, especially young people, had been wrongfully convicted, that the government did something bad, you know, bad prosecutors, bad testing, bad police officers, led to some individuals being incarcerated wrongly. And the only thing we can do when that happens is to give money. And we set up a standard by which individuals who claim that they were wrongfully incarcerated and their liberty should not have been taken away from them, to prove to a certain level that they were innocent. So what we have before us here today, as you rightly point out, is no evidence of actual innocence. And what you're doing here today, you're helping the system. And, you know, the claims commissioner's here. He's hearing from you today. He's hearing from your family members. And I'm hoping that he's seeing that there's a face on the other side of these cases and that he has to do his job. And he has to determine correctly that there was innocence. Otherwise, as you say, and you argue here today, there should not be a payment because that's the system. And we all do rely upon the system. And I thank you for recognizing that you rely upon the jury system, which, you know, was utilized in this case. So once again, it's rare that people come to us, but what you're saying to us is very powerful here today. So thank you, Mr. Chairman.
Thank you, Representative Fishbein. Further comment or question from members of the committee? Further comment or question? If not, thank you very much for joining us this afternoon. Mr. Maceo Troy Streeter. When you're ready, just hit the button in front of you to turn on the microphone and introduce yourself, and you have your 3 minutes. Hit there you go, it's on.
Okay, thank you, Judiciary Committee. My name is Maceo Troy Streeter. I thank you for the opportunity to speak. I am here to ask you to confirm the Claims Commissioner's award in my case. In 1990, I was 26 years old. I had a good job at S&ET Telephone Company. I was a union member. I had sole custody of my son. I was a member of a church. I was building a life. On May 8th, 1990, Terrence Gamble was murdered on Argyle Street in New Haven. I did not commit this crime. I was not there. I extend my condolences to the Gamble family, as I always have, and I want this committee to know. The case against me was built on coerced testimony. The state's only eyewitness has now said under oath, this man is innocent. He's always been innocent. He described how detectives would not take no for an answer. Another witness, 12 years old, when detectives brought him in without his mother and threatened to charge him with accessory to murder unless he signed my picture. There was never any physical evidence. No fingerprints, no DNA. They found gun shells at the scene. They got enough fingerprints off the gun shells to say that they're not mine, but not whose they was. If you take away the perjured testimony, there's nothing tying me to this case. No evidence, because I didn't do it. Lisa Bull DeLulo, a retired FBI agent of 23 years and the former wife of the lead detective on my case, has submitted testimony to this committee. Based on what she personally witnessed, she has confirmed that the coercion the witnesses described is consistent with a pattern she observed firsthand. This same detective wrongfully convicted Stefan Morant, who has already been pardoned and compensated by the state. In 2022, the Board of Pardons granted me a full pardon. My case is listed in the National Registry of Exonerations. When I submitted my application to the Board of Pardons and Parole, I listed innocence from the start. So before they even selected my application, they knew what I said. And then during the hearing, I expressed it more than once. I'm convicted of a crime I didn't do. I did time for a crime I did not commit. When I came home, I chose to serve my community. I was elected alder of the 21st Ward. I serve on the Public Safety Committee and the Homeless Advisory Commission. I work at a warming center in the city of New Haven, helping people who are homeless find shelter. No dollar amounts give me back the 23 years, but this award is the state of Connecticut saying, we got this wrong, and we take responsibility. That means something. I am asking you to confirm the commissioner's decision. Thank you.
Thank you, Mr. Streeter. Comment or question from members of the committee? Comment or question, Representative Staffstrom.
Thank you. And Mr. Streeter, thank you. This is a really, I think, important discussion today, and I appreciate you being here. The comments you made to us about the lack of evidence and the coercion.
Correct.
Did any of that get submitted to the Claims Commissioner as part of the hearing before the Claims Commissioner?
They may have, my attorney may have submitted it on paper. I know I had the lady from the Innocent Project, she was there. I think she testified. I had, let me see, I think he may have submitted it on paper to them. But I know my application itself, when I submitted to the pardon board, it was based on innocence.
Okay.
And I wasn't asked anything about it
yeah, no, I understand that I understand that part. I think I understand that part. But I guess, you know, I mean, I do find sort of the testimony from Ms. DeLulo compelling. I obviously take your statements with respect to coercion and information that's come out since, you know, more recently, since your conviction seriously. I guess sort of my thought or suggestion on this is, or question really is, whether any of that was submitted sort of at the Claims Commission level, whether there was a full sort of hearing at the Claims Commission level of, here, Mr. Claims Commissioner, are the grounds consistent with innocence that I believe exist.
As I stated, I think my attorney may have submitted it in writing, but as far as testimony there, no, because I didn't know.
Okay, all right. And I get you're asking us to confirm this decision.
Correct.
And you were here when the Attorney General's office asked us to deny this decision. To me, I think there's a middle ground here, which is that there should be a full hearing, evidentiary hearing before the Claims Commissioner, where frankly, you know, you present all the evidence that you know, may very well be very compelling on the coercion, on the testimony from Ms. DeLulo and others, you know, and the Claims Commissioner weighs whether that is enough for grounds consistent with innocence. I know that's not your ask of us, but if that was the decision of this committee to send that back to the Claims Commissioner to be heard, is that something you could live with?
Yes, I would respect that.
Okay, all right, I appreciate that. Thank you, sir.
Thank you.
Thank you, Representative. Further comment or question from members of the committee? Further comment or question? If not, thank you very much for joining us today.
Thank you for your time.
Representative Nuccio.
Good morning. Thank you very much for having me. As I have to say, I have never actually attended a judicial committee hearing, and this has been a rather interesting morning for me. I am testifying here today in support of HB 5266. I submitted this here by request of somebody in town I've talked to quite a few times, and also quite a few other individuals in regard to the transferring of property upon death. I know we have a lot of people that are speaking against this right now, and one of the things that I wrote down from prior testimony before I get into mine is that for the last 10 years, this has been coming up and it has not been forwarded. I think that gives us enough precedence to say that there is some sort of compromise to be had here between the asks that we've had from the residents of the state of Connecticut and the lawyers who, to be quite frank, this is part of their business. This is something that they profit from. So I think there is some room here, whether or not it be the language that has been submitted or something that we can find as a compromise to meet what we've seen as a 10-year demand now. We also know that 20 states have enacted legislation like this, so perhaps a review of what they've enacted and any pluses or minuses that we could do to make the legislation better. As we know, most families, their home is their primary asset. It's the most important source of stability and generational wealth that they have. And when homeowners pass away, I've seen this firsthand when my father-in-law passed away and my mother-in-law, who was a stay-at-home mom, had to deal with transferring property through probate and how confusing it was, how time-consuming it was, how costly it was, and the length of time that it took for them to actually transfer over all the property that was not in both of their names. It is pretty stressful for a family that's already grieving, and it is something that I think kind of delays the healing process. So this act provides a simple solution. Again, it might not be exactly what we think would be the best thing, like perhaps a review of the 20 states that have that, and we can come up with the best practices on this. But my concern right now is really just reducing the legal costs, easing the burdens, making basic estate planning more accessible, especially with seniors, families, stuff like that. And just some common sense measures that promote the stability and preserves family wealth. So I'm not a lawyer, as you all know, I'm an accountant. I gladly answer any questions that you have, but my ask is if all of the lawyers are totally against this, then perhaps we look at what we can find from a 10-year ask and how we can make this a reality for our residents.
Thank you. Are there questions? Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Representative Nuccio. I'm trying to figure out, I mean, perhaps the opposition comes from that, not that we make money, but that there's no need for this. So I'm trying to figure out, the scenario that you gave us was two married individuals own a piece of real property, right?
Well, if I'm going back to what happened when my father-in-law died, they don't necessarily both own, they don't have their names on it. For instance, a car or a boat or, the house, yes, both of their names are on it, but there are other items that they don't have both of their names on.
Okay, so in your particular incident that you're talking about that took a lot of time, money, what was the piece of property? Real property, personal property, what was it?
Personal property, I would say. It's been a long time. And again, I'm not asking this for basically what occurred back 30 something years ago in my case. It's just what I'm getting from the residents in town, especially regarding, transfer of property upon death, and just making the process easier and something that's not as long and costly and confusing for people.
So once again, I'm trying to figure out, well, first of all, are any of those people going to testify here today?
One of them is definitely testifying today, I believe.
Can you identify that individual's name?
Sure. His name is Robert Volk, Valk. I believe he is testifying. He also wrote in testimony.
Okay, I don't see a Robert Volk on our list. But moving aside from that, when, like, my house is in my wife's name and my name, and it's in what is known as survivorship. If I pass, probate doesn't really get involved. It goes to her by right of that title designation. If I have a car and it's in both of our names and I pass, she owns it. So and that's why in screening, we're trying to figure out what is the actual scenario that we are looking to solve by this proposed legislation, because it still has not been identified to me.
I would say for people, again, like if I think back to when my father-in-law died, not all of his property, his boat, his cars, and stuff like that were in both names. My mother-in-law's name was not on that, right? So all of that had to go through probate, which was long and arduous, and trying to find all the documentation and all that when you're dealing with the sudden death of somebody. Perhaps if they're married, the default should be that it goes to the married person. Again, I'm not a lawyer. All I'm saying is if we've had 10 years of people asking for this, then it is an issue that has not yet been resolved, and maybe there's some compromise to be had to help people. But obviously it's not something that has both names on it, right? I know my husband's grandfather died, same sort of thing. His name was on a second piece of property. And of course, his grandmother's name wasn't. Much older generation didn't have the same forethought to make sure husband and wife were both on there. Having to go through probate for that with a really older woman who definitely doesn't have like all the old paperwork and everything. There are obviously instances where not both spouses' names are on property.
Okay, so John Smith owns a boat, and he's married to Mary Smith. John Smith, upon his passing, is no longer an individual and can't sign a document transferring to Mary Smith. You would have the legislature say that Mary Smith automatically gets it without contest. Is that what's before us here today?
It's a possibility. It's a possibility to think about, married couples, what they would have to go to probate for and not. If there's not a spouse, then obviously you'd go to probate for the next survivor. But in the case of a married couple, perhaps that would be what it is.
Okay, so what happens when there's a will?
Well, obviously, I would assume at that point you would follow the will.
Okay, the will would go to probate. Probate would make the determination on whether or not the will is valid and approve transfers, right? I'm just trying to figure out, once again, I'm gonna stop, but I don't see an issue here, quite frankly. So, but thank you, Mr. Chairman.
Further questions or comments? If not, thanks for being with us, Representative Nutro. Kenneth Rosenthal will be next.
Oh, thank you. My name is Kenneth Rosenthal. I've been a lawyer here in Connecticut for more time than I want to remember, more than 40 years, involved in both the criminal justice system and the civil system. And I've had the privilege of representing some claimants before the Claims Commissioner this year and in previous years. From what I know, and I'm in touch with most people who do this kind of work, or many, there's not a lot more cases in the pipeline. Thanks to Commissioner Shea's work last year and this year, a tremendous backlog has been eliminated. And from where I sit, I don't know of many other cases you're going to be seeing, certainly not what you've seen this year and last year. I'm here on two claims, HJ number 6 and SJ number 6. The first, HJ number 6, Charles Coleman, was imprisoned for 38 years The state's attorney's office, to its credit, and the state's CIU and the state's own forensic lab determined in 2024 that he did not commit the sexual assaults for which he was convicted and for which he served prison 38 years, 14 and a half years of which were in solitary confinement, which is one of the, because of the fact that he was subject to violence, he insisted on not having a cellmate, so he got put in solitary confinement. His perseverance is just unimaginable. And we're here, and I think the system, again, worked the way it did in this case. This is not a pardon case. This is a case where the state's attorney's office and the state's own people, knowing the evidence, found that this is not a case that he should be exonerated. He was, and we had a full-day hearing before the Claims Commissioner in which evidence was presented. Witnesses were cross-examined by the Attorney General's office. A determination was made by the Commissioner, and I think not everything we asked for, but nearly, and I think the system worked the way it should. The second case I'm here on, SJ number 6, Louis Galarza, who is one of, I think, the only claimants you've seen under 54102 UU who was convicted of a capital offense, serving a sentence of life without parole in prison for 23 years. This is out of Bridgeport. And to his credit, the state's attorney for Bridgeport in 2024 again determined, based on evidence that was developed over 5 years at a post-conviction proceeding that was handled in our post-conviction courts, determined that justice would be done. Those are his words, that he lost confidence in the conviction, such that the conviction was vacated on his motion and by his agreement, by the state's agreement. And subsequently, in really the shortest time gap between the vacating of a conviction and the dismissal of the prosecution was dismissed. And so I would ask the committee to approve both of these awards. I think the system worked, as Judge Dayton said at the hearing, the way it should work. If there are questions, I'm happy to answer them.
Are there comments or questions from members of the committee? Comments or questions? There are none. I want to thank you very much for joining us and providing us with your testimony.
Thank you, Senator Winfield.
Have a great day. James Doherty. Good afternoon. You may testify once you're seated.
Good afternoon. Thank you for your time. My name is James Doherty. I'm here on behalf of the Estate and Probate Section of the Connecticut Bar Association to testify on Bill 5266, an act adopting the Uniform Real Property Transfer and Death Act. The Connecticut Bar Association's Estate and Probate Section does oppose this legislation, and the stated goal of it is a good one, of making property transfer happen easier, meaning faster, less costs. We are all for that. As estate planners, we help our clients do that. We use non-probate transfers. And something that was stated by in the testimony supporting this bill is somehow we as attorneys benefit from having a more complicated process. That just shows a fundamental misunderstanding of how the business of law works, where in trust estates, our goal is to have relationships with our clients. A really good way to end those relationships is having a complicated process. So we have done a lot with this committee, and this committee should be very proud of itself. Over the past decade, I don't think any state has done more to modernize its estate and trust law than the state of Connecticut has. And a lot of that has been through the passage of laws promulgated by the Uniform Law Commission. But this one we do oppose because we don't think it achieves its stated goal. The idea that it's simple, if you read it, it is a 12-page, lots of technical definitions, and conflicts with lots of parts of existing estate law. And non-probate transfers aren't simple. Just last year, the Connecticut Supreme Court had to deal with a case dealing with non-probate transfers, other assets not working out well, because the person using them didn't understand them properly. So there are two technical issues we have with this bill, big kind of umbrella. One is something that's always an issue with uniform laws in the state of Connecticut. It's because our court system's different. A lot of other courts, there's just one court that deals with estate matters. In Connecticut, we have probate court, deals with some, superior court others, and other matters are dealt by one or the other. So this bill has not been crafted to address our jurisdictional concerns like other uniform laws have. There's also the funding issue. The probate courts heavily rely on funding from a fee imposed on estates. Proponents of this legislation says this avoids probate. It doesn't. You still have to report the property to the probate court and pay a fee on it along the way. We also have concerns over what this does for individuals in the state. One is exploitation and abuse. This has a lower standard of capacity than any other non-probate transfer without the formalities that wills and court oversight offers with last wills and testaments, which is one of the reasons you're more comfortable with a lower level of capacity because you have that court oversight. There's also just the issue of confusion with things because a lot of people think of who gets what when they're making their estate plan. They don't think, well, who's picking up the tab on bills? And this legislation doesn't address it. So we think, like other uniform laws, there should be a process. First, Representative Fishbein, you already addressed this. Is there a need for this in the first place? There are a lot of other mechanisms to transfer real estate under existing law. If there is that need, we have to look at, is this a viable concept? A lot of states that have these transfer on death deeds did not use the uniform law as a basis. So just like every other uniform law this committee has enacted, it should go through a rigorous review process rather than simply be enacted. Thank you. I'm happy to take any questions.
Thank you very much. Representative Fishbein.
Thank you, Mr. Chairman. Thank you for coming here today and giving your perspective. You know, one of my biggest concerns, quite frankly, is the undue influence aspect. I've done quite a few cases involving undue influence, and you know, you really can't tell it to the full extent without going before a finder of fact. And to have these transfers, you know, especially more elderly people. You know, I have people complaining to me about solar contracts that, you know, people in their 80s are signing that, you know, binds the property for another 30 years and stuff like, and then the subsequent owner has to assume that. I mean, we have to be cognizant of people that can be taken advantage of. So, but once again, I thank you for your testimony here today.
Thank you.
Thank you, Representative Fishbein. Is there a comment or question from other members of the committee? Comment or question? There is none. Thank you very much for joining us and providing us with your testimony.
Thank you, Senator.
We have Eric Chester. Good afternoon. When you are seated, you may testify.
Good afternoon, honorable members of the committee. My name is Eric Chester. I'm an attorney with the firm Ferguson, Doyle & Chester, and I'm here to testify in opposition of House Bill 5267, an act concerning eligibility for incapacity benefits under the Workers' Compensation Act. Our firm represents a number of workers throughout the state of Connecticut. We've represented a number of injured workers before the Workers' Compensation Commission, including teachers, firefighters. We represent the Uniform Professional Firefighters Association of Connecticut, as well as AFT Connecticut. House Bill 5267 would fundamentally undermine nearly a century of settled workers' compensation law. It would harm injured workers, and it would improperly shift costs from insurers onto retirees. As members of the committee undoubtedly know, workers' compensation is a remedial statute designed to provide wage replacement and medical benefits to employees who have been injured on the job. Employees who are totally disabled due to a compensable injury and require medical treatment have always been eligible for temporary total disability benefits while they are recovering from their injuries. Just last year, our Connecticut Supreme Court reaffirmed this principle in Cochran v. Department of Transportation, holding that a claimant is eligible for total incapacity benefits regardless of whether the disability occurs before or after retirement. The court emphasized that the statute contains no age or retirement limitation and leaves disability determinations to the Workers' Compensation Administrative Law judges. House Bill 5267, as proposed, goes far beyond that decision. It would impose a blanket denial to benefits to any retiree regardless of the reason for retirement or the severity of their work injury. This is an overly broad and punitive change that favors insurers at the expense of injured workers. Just a couple hypotheticals as to the consequences of this bill. If you have a firefighter who retires after 30 years of service and then subsequent to retirement requires surgery for an injury that they sustained on the job, and then was totally incapacitated, this bill would deny that injured worker those benefits. The same would be true for a nurse who retires due to work-related injury and then later needs surgery to repair the knee that was injured on the job. And would be out of income post-retirement, perhaps working a second job. This bill would deny her those benefits while she's totally incapacitated. These outcomes contradict the purpose of the Workers' Compensation Act and the unfairly penalize workers who spent their careers planning for their retirement. In sum, I would say that retirement from one job is not retirement from the workforce. Most people who retire continue to work into their retirement.
Okay.
This bill would deny injured workers who suffered an on-the-job injury subsequent benefits post-retirement simply because they retired from one job, not because they retired from the workforce.
Thank you.
Thank you.
Comment or question from members of the committee? Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon,
Good
Attorney
afternoon.
Chester. I know something about this field. As a member of my local town council, many times we're entering into agreements that resolve an open workers' compensation claim. And I'm just trying to put this all together. Not that I'm a proponent of this, but I just want to learn more about what's before us. If there's an agreement to retire as a result of a work-related injury, and then the person subsequent to the agreement needs surgery, who is on the hook for that surgery?
Good question. It depends on what that agreement says. Oftentimes, when there's an agreement to fully and finally resolve a workers' compensation claim, that term would be spelled out in the agreement. So you may see agreements that will say, for a certain sum of money, where the employer or the employer's insurance carrier is no longer responsible for future medical treatment. It may say that, it may not, but those would be governed by the terms of that agreement.
Okay, so this language would only apply to those individuals that retire voluntarily, or if an agreement is open-ended?
This bill, as proposed, would apply to any employee injured on the job, then retires from that job, may need a subsequent surgery for that injury, is out of work, incapacitated from work, they would be denied benefits during that period of incapacitation. That's the result of this bill, this proposed bill.
Yeah, I don't know where it comes from as
Yeah.
far as, who submitted it, so I'm just trying to figure out, was there some, recent, Supreme Court decision that, somebody's looking to fix or something?
There was.
Oh,
Yes,
okay,
yes.
please.
I referenced it in the testimony, the Cochran versus Department of
Yeah, you
Transportation
said it.
decision. Yeah.
Yeah, and so what did Cochran hold?
It held that case was, I read it narrowly, and I think the court worded it narrowly, where there the claimant testified consistently that he had no intention of ever returning to the workforce. And so the court there said in that case where the claimant testified consistently that he had no intention on ever returning to the workforce, the Supreme Court stated that he would not be eligible for wage replacement benefits post-retirement.
Okay, I understand. Yeah, I think I do remember. Okay, thank you, Mr. Chairman.
Thank you, Representative. Representative Fazino, I almost put you forward in time.
Thank you, Mr. Chair. Attorney Chester, good to see you. So I guess just sort of the other consideration in my mind is I remember we addressed this last year as a committee. I remember reading Cochran last year when it came out. Intent is really hard to gauge. And so I think to your point in your testimony, just because someone at one point in time might consider leaving one aspect of the job they do, they might very well pick up and do something else. So I was just wondering if you could speak a little bit more to sort of the intent issues at play and why that might create complexities in the workers' comp statutes and how they're interpreted.
Yeah, I agree. It's almost impossible to ascertain somebody's intent as to what they're going to do into their retirement. But I think I would just reiterate what I stated earlier. I think it's uncommon for someone who retires from a job to say, I'm never working any job ever again. Now, in the Cochran case, the claimant did say that. But I would say that that's the exception, certainly not the rule. And for this bill, as proposed to become legislation, suggests that if you retire from a job, you're somehow implying that you intend to never work again. That's just never the case, almost never the case. I'm not sure if that answers your question.
Yeah, it does. I could imagine very infrequently you have someone, I mean, you handle many more workers' comp cases than I probably ever will, but very rarely do you have someone explicitly say, this is my intention, this is what I know I'm going to do, and actually follow through consistent with what their representations are. So appreciate your testimony as always, and thanks for being with us today.
Sure.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us today and providing us with your testimony.
Thank you for having me.
Okay, next we have Douglas Lieb. Good afternoon.
Good afternoon. Thank you, Chairman Winfield, members of the committee. Attorney Douglas Lieb on HJ number 4, the Claims Commissioner's Award to my client, Michael Smith. I'm here today really for two purposes. The first is just to answer any questions or address any concerns that any members of the committee may have. We think it's very clear with respect to the Commissioner's finding of Mr. Smith's eligibility on grounds consistent with innocence. This is not a pardon case. This is a post-conviction review case where the conviction was overturned by the Superior Court. The state declined to retry Mr. Smith for that offense. I'm happy if there are any questions to get into the record evidence that supports the Commissioner's finding, but that's number one. Number two is that this case does raise an issue that Representative Staffstrom had addressed before, which is how compensable time is calculated when someone is serving another sentence concurrently for unrelated matters. And, the Commissioner has taken what I would characterize as sort of a mechanical or sort of black and white approach to that question, which is that if you have any other concurrent sentence on the books during a portion of your incarceration for the vacated conviction, you can't be compensated for that time. I would refer the members of the committee to the written testimony that I submitted yesterday morning on this issue. We think the better approach is what I would say is sort of a pragmatic or fact-based approach, which is trying to figure out actually how much time would this person have spent in custody but for the wrongful conviction that got vacated. And I think Mr. Smith's case illustrates why that's the better approach, because Mr. Smith, after having already been wrongfully convicted of the vacated homicide charge, took a plea to some other pre-existing drug charges afterwards that gave him a period of 10 years that ran concurrently with the vacated homicide sentence. And in the real world, people do not serve until their maximum release date on 10-year sentences for nonviolent drug distribution offenses. And so the approach that the Commissioner took was to exclude basically all of those 10 years through the maximum release date as calculated by DOC. We were asking for sort of a factual inquiry into when would Mr. Smith likely have been released from prison but for his vacated wrongful conviction. And obviously that's not an easy question to answer necessarily. But from our perspective, the preponderance of the evidence adduced at the hearing established that he would have been released several years earlier at a minimum. So in an ideal world, I think this committee would remand for the limited purpose of addressing that factual question, right, and saying the way to analyze this is not just a black and white, if you have any other sentence on the books, no compensation, but rather we should factually inquire into when you likely would have been released, but for the wrongful conviction. But in the alternative, if that's not what this committee would like to do, we would ask you to adopt the resolution and confirm the award. I welcome any questions.
Thank you. Representative Staffstrom.
So I hear you on your ask, and I think it is intellectually it's an interesting question, right, about sort of how do you calculate. But if the Claims Commissioner didn't take what you described as sort of the mechanical view on this, I I know Mr. Shea, I know he can hear testimony, et cetera, but it would seem like there is a very fact-intensive inquiry and quite a bit of speculation that would need to go into, okay, well, instead of serving 10 years, he would have served 3. How would he be able to make that determination on a case-by-case basis?
I think it's a very fair question, and I think, claimants in our position would have to be put to their burden. I'll tell you that at this hearing, what we did was, we had a witness from DOC come in and sort of run through a bunch of different alternative calculations, and we had a DOC witness establish what Mr. Smith's parole eligible date would have been on those unrelated nonviolent drug charges, and that was uncontroverted. It was from DOC. What we also put in evidence was official records. I can't remember exactly what they're called, but they're official reports of the state that, indicate the historical parole grant rates for every month during the period of time in question, which were well in excess of 75% at the time, right? And so can we reconstruct with precision what would exactly have happened at a hypothetical parole hearing for Mr. Smith? No, it's counterfactual. But I think the preponderance of the evidence established is that he more likely than not would have been granted parole at the time he became eligible, based on the nature of the offense and the historical precedent of how parole was being granted at the time. That's how we approached that question. And so you can envision other approaches in other appropriate cases. And I'm not saying it's easy, and I see the allure of the black and white or bright line approach, because it makes what is already a difficult job that the commissioner has a bit easier, but I don't know that it's consistent with the purpose of the statute, which is to compensate people for time that they spent in prison that they wouldn't have and shouldn't have otherwise. And so, that's why we think it's the better approach.
Yeah, no, I hear you. But on the precedent issue, and I don't, maybe you can't answer this. I don't know how much work you do before the claims commissioner on these. If this was a one-off or you do.
I've had a few others.
Okay, so maybe you can then. So the way that the claims commissioner applied the statute here, is that consistent with how you've seen it applied in other cases, or you haven't had this circumstance before?
So to my knowledge, this circumstance has really arisen in the last couple of years. It comes out of a decision called Gaskin. It was the claim of Christopher Gaskin, which I think came up before this body 1 or 2 years ago. And, in Gaskin, the claimant had committed a series of violent offenses. He assaulted someone on video while he was in prison. There were ample reasons to why no one thought he should be getting any more compensation beyond sort of what the letter of the statute sort of strictly entitled him to, that I think made it unnecessary to go into a deeper inquiry, right? And so the commissioner issued a decision in Gaskin that said, if you have concurrent time, you're not getting compensation. And I think the question that's now playing out is Gaskin a per se rule of law that says, if you have any concurrent time, you can never get compensation for any of it? Or is Gaskin one application of the general principle that you should be compensated for your wrongful time to the facts of Gaskin? And is there at least room for other claimants who are differently situated, like Mr. Smith, to make it a factual argument that actually some of the time where I had a concurrent sentence is wrongful? I mean, you can imagine a situation where someone where the wrongful conviction serves as a predicate for a subsequent sentence on an unrelated charge that then becomes longer and it is directly affected by the fact that you were wrongfully convicted. And obviously, if you're standing before the court being sentenced on a drug case convicted of a manslaughter, your sentencing outcomes are going to be different than if you're standing in front of the court on a drug case not having been convicted of a manslaughter. And so I think there is precedent applying it this way, but I think what I think I'm essentially saying is that the commissioner understands that precedent to be a per se rule of law, and I think the better approach, which is not inconsistent with the way it's been applied in the 1 or 2 cases I'm aware of, is to think of it as how do we isolate the portion of the time in custody that is wrongful? And what is the correct factual determination of that on the facts of each individual case? I think that's the better reading of the Gaskin precedent.
Yeah, I mean, I hear you. I think it is a balance. I mean, I go back to 2015-ish, which I think was sort of the first real sort of rewrite and when the statutory formula came into effect on the wrongful incarceration. I don't even know if I was technically vice chair of the committee at the time, but you know, at the time the committee was dealing with a couple very large wrongful incarceration awards that had come out of the Claims Commissioner's office, and there was no guidance in statute whatsoever. It was the complete Wild West and the absolute discretion of the Claims Commissioner to award whatever they felt like was appropriate. And the legislature at the time, I think, was a little aghast by it and basically said, well, wait a second, what do you mean there's not some sort of framework or parameters? And so, you know, that's kind of how we ended up with this, what I would consider evolving process we still have. But I do think the intent really was to sort of rein in the discretion of the Claims Commissioner in many regards and to say, this is what folks get, and to try to treat people generally the same when they come before the commission, so that you're not having somebody who's getting $10 million and somebody's getting $10,000 for similar circumstances.
May I just
Yeah,
briefly
please.
respond? I mean, I agree with that, and I'm familiar with the statutory history, including the recent amendments. I think the only thing I would say in response to that is that really none of this is in the statute, because what the statute says is if a conviction has been vacated or reversed and the charge is dismissed on any one of the now 3 specified grounds of eligibility, the commissioner shall issue an award compensating claimant for such wrongful incarceration, right? That's what the statute says. The statute doesn't say actually anything about what you do with concurrent time. All of this is basically a gloss that the commissioner, I think, had to come up with something on the question of what is such wrongful incarceration. I don't think anything in the statute really speaks directly to this issue. And so I hear you, but I think this is an approach that the commissioner has adopted, which there needs to be some approach, but none of it is really statutory. And I do think the better approach is one that in appropriate cases, and I believe this is one, would allow a claimant to make a factual showing that actually some of the time in which they were technically serving a concurrent sentence is really proximately caused, to use a legal term, proximately caused by their wrongful conviction that's vacated for which they are seeking compensation.
All right. I hear you. I appreciate the exchange. I'm not quite sure and I'm buying it, but I appreciate the exchange.
Thank you, Representative. Comment, question from other members of the committee? Comment, question. Seeing none, thank you for joining us today.
Thank you very much.
Brooke Foley. Good afternoon.
Good afternoon, Senator Winfield, Representative Staffstrom, Vice Chairs, Ranking Members, and distinguished members of the committee. My name is Brooke Foley, and I'm here today on behalf of the Insurance Association of Connecticut. Thank you for the opportunity to comment in support of House Bill 5267. We have submitted testimony for your review, but I'll just make a few comments. This bill reinforces a core principle of the workers' compensation system. While individuals who retire remain eligible for workers' compensation benefits in appropriate circumstances, total incapacity benefits should only apply when a workplace injury results in actual inability to work and earn income. Workers' compensation benefits are intended to address the loss of earnings that occur when an employee is injured on the job and can no longer work. Allowing benefits in situations where there's no loss of wages by workers who have voluntarily left the workforce for a reason unrelated to a workplace injury risks diverting limited resources away from employees who are actively working and who depend on the system after a disabling injury.
Insurers need predictability when they're assessing risk. Allowing claimants to file claims for total incapacity years after they have left the workforce increases costs and uncertainty for employers, municipalities, taxpayers, including the state of Connecticut as a major employer. For these reasons, we respectfully ask the committee to support House Bill 5267. Thank you.
Thank you. Thank you for the brevity, too. Comment or question from members of the committee? Comment or question from members of the committee? There are none. Thank you very much for joining us today.
Thank you.
Is it Edie Patino?
Yes, thank you. Can you hear me all right?
Loud and clear.
Okay. Thank you, Chairman Winfield and Staffstrom, ranking members Kissel and Fishbein, and esteemed members of the Judiciary Committee. My name is Edie Patino, and I'm the Associate Director of the Jewish Community Relations Council for the Jewish Federation of Greater Hartford. I'm here today to express strong support for SB 90. And I just wanted to emphasize a few key points from my written testimony that I provided. One being that we believe hate crimes are very different from other crimes. We believe them to be message crimes intended not only to harm an individual, but to intimidate an entire community. SB 90 addresses a very practical problem. Connecticut's hate crime provisions are spread across different sections with inconsistent terminology and definitions. This bill organizes, consolidates existing provisions, aligns definitions, and makes the law easier to find, understand, train on, and apply, so justice doesn't depend on which statute someone happens to locate first. Like many others, the Jewish community is feeling more vulnerable. And in a moment when targeted communities across our state are feeling more vulnerable, Connecticut should ensure its hate crime statutes are clear, consistent, and usable. On behalf of the Jewish Federation of Greater Hartford, we respectfully urge the committee to support SB 90. Thank you again for the opportunity to testify.
Thank you. Comment or question from members of the committee? Comment or question? I don't see any. I just want to thank you for coming to testify and also for summarizing the major points of your testimony.
Appreciate it. Thank you so much for your time.
Thank you. Have a great afternoon.
You too. Take care.
Okay, the Honorable Beverly Strite. Good to see you again. When you're ready, you may testify.
Good afternoon, Senator Winfield. Move over the mic. Thank you. Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. I am Beverly Strite, the Probate Court Administrator. I have submitted written testimony in opposition to Senate Bill 261, an act concerning transfer of a motor vehicle registration upon death of the owner of the vehicle, and to House Bill 5266, an act adopting the Uniform Real Property Transfer on Death Act. I note that I endorse the written testimony submitted by others also in opposition to House Bill 5266. Applicable to both proposals must be a recognition that family strife, contested matters in the probate court over inheritance and transfer of assets on death among family members, and the undue influence and exploitation of not just the elderly is on the rise. TOD, or transfer on death designations on assets, can certainly be an appropriate step to simplify transfer of assets, and we certainly have worked in the past on legislation to accomplish just that. However, such designations and mechanisms must be appropriately tailored to ensure clear legal rights, protection of unaware and vulnerable consumers, both on the transferor and the transferee side of the equation, as well as recognition and of established procedures to adjudicate when things go wrong, which they do very frequently. Both proposals, as currently drafted, will expose and increase exploitation and will not streamline nor, frankly, probably expedite non-probate transfer of assets, and may, in fact, increase the delay due to litigation and increase disputes and confusion over ownership of the assets, and, frankly, in the end, may cost people more money. I respectfully oppose both proposals, and I'm happy to answer any questions.
Thank you. Are there comments or questions from members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Your Honor.
Good afternoon.
I share in your opposition. You know, I think part of the problem is, and I don't know if you have statistics. You know, we hear all the time up here, that damn probate court system, it takes too long and it costs too much, and I'm usually hearing that from people that have nothing to do with the probate court system. So do you have some sort of document that talks about, like especially on decedent estates, you know, the average time that it takes to close a decedent estate, the average cost, that kind of stuff? Do you have that information?
We do not collect data per se on the average time it takes to complete settlement of an estate. And one of the challenges can be that there are so many unique circumstances of many matters, whether it's contested or uncontested, how quickly individuals file necessary documents with the probate court, nor frankly the cost associated with hiring attorneys or anything of that nature. I'm not really sure how we can address that issue. I can share with you that the probate courts are reviewed biennially. We do look at ensuring the expeditious scheduling of matters, as well as the completion of decrees, especially in contested matters. I have to say, our judges and court staff recognize very strongly that these are personal matters of sensitivity to many families, whether it's uncontested or contested. And so enhancing all of those efficiencies and the attention to those matters is of paramount concern to us.
No, I appreciate that. And as you say about the difficulty about collecting data, it brings to my mind, my attention, my memory. I recently had a case. The town of Meriden did a tax foreclosure, and the property was half owned by somebody who passed 30 years ago, and the estate got closed out without recognition for the house. So now, you know, we end up with a pot of money because the town took their money, and then there's procedures by which the rest of the money have to, you know, so now I've got an estate that was closed out 30 years ago. And, you know, bringing it to the attention of the court that, hey, there was a house here and you got to do something with this. And that essentially would have prolonged the closing of that estate. And I don't know how you would ever keep those stats. But, you know, I will bring to your attention, we hear that frequently up here. You know, and the other thing is, and Evan and I were talking about this, I'm hoping that you're going to get rid of turbo court like next week. I know it's not going to happen next week, but, you know, as I've expressed to you before, that system from this side, I don't know about your side, but from the practitioner's side is extremely difficult to work with. You know, when something gets filed and it just says miscellaneous document, and there's not a hyperlink to it, and I've got to go access the system and find what it is, you know, the federal court system, it just says, and there's a hyperlink there for my email. So I'm hoping that we're working towards something that's a lot more usable from this side. But thank you, Mr. Chairman.
Take that under advisement. I would note that e-filing systems are not inexpensive, and tailoring some of those protocols is cost prohibitive. But we will certainly take into consideration your concerns. I know you've expressed them to us on a number of occasions, and we have tried to implement what we can effectively and efficiently adjust, especially for the benefit of individuals who have a high number of cases. You may be familiar with the My Cases feature that was not initially part of the development of our turbo court system, but we endeavored and expended necessary funds to develop that feature because of the beneficial nature of it to so many. And we'll certainly continue to act on feedback that we can adjust for.
Thank you.
Thank you.
Thank you. Comment or question from other members of the committee? Comment or question? Seeing none, thank you for joining us again.
Thank
Have a great
you.
afternoon. David Warren. David Warren. Heather Fielder. Heather Fielder. James McCall.
Yes.
You may
Can you hear me?
Yes, we can hear you.
Excellent. Good afternoon, Senator Winfield, Representative Staffstrom, fellow committee members. My name is James McCall. I am testifying today in opposition of raised bill 5267. I actually represented Mr. Cochran in that Supreme Court case that was discussed earlier by Attorney Chester. I wanted to just maybe clear up a couple things about that decision. Attorney Chester misstated slightly regarding the ultimate finding of the Supreme Court. They did ultimately rule that Mr. Cochran was eligible for total disability benefits pursuant to 31307, and that was despite the fact that he testified at his trial that he did not, at the time of his retirement, have an expectation to return to the workforce. And that's because 31307 isn't necessarily just a lost wage benefit. If you look at the language of 31307, it talks about the loss of earning capacity. And that's really what the Supreme Court was getting at in their decision, is that you have these individuals who might retire and then return to the workforce at a later date. And you don't know at the time of your retirement what your future intentions are, which I believe Representative Lozano was getting at earlier. A couple other things to just combat some of the testimony from Attorney Foley regarding these municipalities and the benefits being offset. So there's a couple provisions in statutory right now, specifically 5-170, which applies to state employees. If someone is awarded a disability pension, according to 5-170, that state employee is not eligible for disability benefits through 31307. Similarly, there's a couple municipalities that have pension offsets. I know that's another bill that's been proposed before this legislative session. And then lastly, if you look at the repealed 31307E, it was what was known as a Social Security offset. That's essentially what is akin to this proposed bill, really attacking disabled retirees. And I think it's pretty clear that this would be unfair and cruel punishment of retirees. And with that, I could answer any questions about Cochran or this in general.
Thank you very much. Comment or question from the committee? Comment or question from members of the committee? There are none. I want to thank you for joining us today and have a great afternoon.
Thank you.
Next, we have Eilish Collins, Maine. You may testify when you're ready.
Good afternoon. Thank you so much. This is my first judicial meeting hearing, and I've learned a lot today. Good afternoon, esteemed chairs, to our vice chairs, our ranking, and the members of our Judiciary Committee. I am State Representative Eilish Collins, Maine, serving the 146, which is comprised of downtown Stamford, the South End, Harbor Point, and Chapin. I'm here to testify today in support of SB 260, a bill to enhance penalties for unlawfully permitting a dog to roam at large. I'm here on behalf of my constituents in a very densely populated district with over 60 tall residential buildings and residential neighborhoods with lots of dogs and lots of dog owners. And I'm also testifying on behalf of one constituent in particular who experienced a tragic and traumatic event as a result of a roaming dog. And I will be brief, we've submitted testimony. My constituent, Deborah, is an elderly woman. She's 75 years old, she's about 5 feet tall, and she was walking her 10-pound Cavalier, Lacey, in her neighborhood. They encountered a roaming off-leash 150-pound dog, a cane corso. The dog attacked Lacey, and Lacey was mauled to death right in front of Deborah. This, according to the animal control, the attacked dog owner had come to their attention in other prior incidences. The current fines and consequences do not appear to be sufficient deterrent to enforce existing no roaming laws. As of course you can imagine, the aftermath for Deborah has been significant mental trauma and now does weekly therapy with a trauma specialist. The tragic event has caused her to experience loneliness, loss of emotional fulfillment, fear, and the companionship of her dog, Lacey. So to summarize, this bill that we like to refer to as Lacey's Law creates stiffer fines and consequences for dog owners who routinely allow their dogs to roam. It is intended for owners who know that their dog has a vicious propensity and owners who intentionally and recklessly let their dog roam. I want to point out what this bill is not, and I think that's what I can contribute to the conversation. It's not a bill designed to penalize those who do follow leash laws routinely. And it's not meant to be punitive for a situation like accidentally leaving your garage door open while getting the kids out of the car, only to have your dog run off and potentially display aggressive behavior. And to that last point, this bill came up last year, and it passed the Senate, and then it came to a vote for the House chamber late in the last session, only to die in a discussion and some confusion about this last clearly accidental scenario in the debate about the merits of the bill. So in summary and in closing, thank you so much for your time this afternoon. I urge passage of this bill, and I will answer any questions that you may have.
Thank you. And for your first time, you did great. Representative Fazzino? No? Yes?
Sure, yeah.
Okay.
I know that thank you, Mr. Chair. And Representative Collinsman, thanks for being with us this afternoon. So I know that we addressed this last year. Any difference in your proposed language this year versus last year?
Thank you so much for that question. Yes. The way this bill is written this year, it is much more clear about what the difference is between roaming and being unleashed, and that this is also about repeat offenders as opposed to haphazard accidents, and about owners that have dogs with these proclivities for aggression. So that really is where the debate broke down in terms of just what was the difference between leashing and a roaming dog.
So for proclivities of aggression, is that just one prior instance of aggression? Is that multiple prior instances of aggression? What's the threshold?
That's a great question. Thank you for it. So what this bill does is it increases the fines for what happens when a roaming off-leash dog is in an aggressive situation. So the first offense is $350. The second offense is $500. The third offense is now a misdemeanor, a Category C misdemeanor. And if another event happens within a year of the prior third event, then the owner is subject to a $1,000 fine and even 6 months in jail. So it does look to enforce these no roaming laws in a way that's more aggressive than the current laws.
And the standard for imposing those fines is an intentional or reckless standard, not just a negligence or inadvertent standard.
Correct. And the animal control officer is involved in how that gets done.
Got it. Thank you, Representative Collinsman.
Thank you so much, Rep. Fazzino.
Thank you, Representative. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, ma'am. State Representative, sorry.
Yes, of course.
I heard your testimony with regard to the distinction between roaming and unleashed. And can you just point me to the section of the bill that you're relying upon for that information? Because I couldn't find it. It's a 3-page document.
Okay. I don't have the bill open in front of me.
Okay, I'll give you a moment. It's 260.
Hold on. Committees. I should have had the bill open in front of me. One more second, sorry.
Yeah, no problem. I'll continue looking while you're looking.
Okay, so if we go to the bill, you're right, it's only a 3-page bill. When you get to the heart of the matter in this bill, scroll down. Hold on. I think it starts with line 32, about any owner or keeper of any dog who, knowing the vicious propensities of such a dog, that makes clear the difference between the garage door scenario of a dog accidentally being unleashed and the repetitive roaming and flagrant disregard for the laws regarding not allowing dogs to roam.
Okay, so let's unpack that. Because I think 32 has to do with vicious propensities. It doesn't have to do with leashing versus roaming. So if we look at the first line, any owner or keeper of any dog who, knowing the vicious propensities of such dog and having violated subsection A, right? So the two together would be required to invoke that paragraph. So if we go back to A, that's actually where you deal with leashing, roaming, and there is no distinction, right? So if you go up to A, it just talks about owners. No owner shall allow dog or livestock to roam. And in fact, as I scan it, the word leash doesn't appear in A at all. So I'm just trying to figure out why you believe, as you testified here today, that there's a unpacking and a distinction in the bill between roaming and unleashed.
Thank you, Representative Fishbein. You raised an excellent point at the point of a public hearing when, if that continues to be something that needs to be further addressed, that we should do that, because that's where the crux of the issue fell apart in terms of what happened in the House chamber, and so we never passed the bill. Okay. So I'm more going to take that. I'm not an expert on all of the elements of the bill, nor on the committee, but if I would say as a takeaway, if you continue to believe we have not made that leash designation versus what is the definition of roaming, then I think that is a good takeaway for the committee.
No, I appreciate the exchange. Would you agree with me that, because, I mean, I heard your testimony, you would agree with me that your understanding of what the bill said is perhaps not what you thought it was. Is that fair?
No, because what I was looking for in this version of this this bill coming back out was that clarity, or having the situation be so personal and in my district. I do know exactly what the bill is intended to do in terms of these dogs that we do know that roam versus dogs that are unleashed at a dog park, or that, you know, that people follow the leash laws that we have in place. So, and I also think that the penalties are called out much more clearly.
Okay, so we're gonna shift to the penalties. As drafted, if someone slipped the leash, well, let's take it this way. Presently, under our law, if the dog is unleashed and is roaming, do you know what the penalty is for the first offense?
I don't know that there is an extension of our leash laws that is considered that scenario, right?
Okay, so I'm looking at lines 15 and 16.
Okay.
It appears that this sentence is bracketed out. Violation of any provision of the subsection shall be an infraction. So I would think that, based upon that right now the first offense is an infraction, right?
The first offense of a roaming dog or a dog that has slipped the leash?
Either, because it's not, the language that's before us doesn't distinguish, in fact, the word leash doesn't even appear in this language, doesn't distinguish. But I'm just giving you the scenario. I mean, I don't want to feed you, you know, a lot on this, but the language before us for a first violation is a criminal penalty. Well, it's not a criminal penalty, but it's a fine of $350, right? For the first violation.
For a situation in which the dog has been determined to be roaming by animal control, the first violation is a $350 fine. That's up from, I think, $50.
Okay. I mean, I read it to be an infraction presently, but I'm just trying to figure out the public policy that we are being asked to follow to go from nothing to 350 when somebody could have, you know, door opens, the dog runs out. I mean, that's what's before us, quite frankly. So,
Which is the issue I raised.
okay. Well, thank you, Mr. Chairman.
Thank you. Further questions or comments? Seeing none, Representative, thank you for being with us this morning.
Okay,
Appreciate
thank you
it.
so much. All right, have a nice afternoon.
You too. Andrew Feinstein.
Hi, Senator Winfield, Representative Safstrom, Representative Fishbein. I'm Andy Feinstein. I'm delighted to be in front of this committee. First time in front of Judiciary, although not hardly first time up here. I'm a lawyer in Mystic. I'm a member of the Hate Crimes Commission, which is proposing and working with the governor on raised Bill 90, Governor's Bill 90. Why do we have hate crimes? We have hate crimes because they're violations not only of somebody else's rights, but they're a violation. They tear at the fabric of society. They undermine our civic order. And so the reason we have hate crimes is they're essentially enhanced penalties in those situations. Currently, Connecticut's laws are scattered all over the place. And this bill is very modest. It merely consolidates the provisions. It makes sure that the class of people who are covered as the protected class in each case are the same. It rationalizes the standards of intent, and it identifies hate crimes as hate crimes. That's all it does. It does not make major changes in what is a hate crime or in the penalties therefore. The reason that we need this legislation is because it is hard to prosecute hate crimes anyways because they're crimes of intent, of a special intent. And so we need it very clear to both the arresting officer and to the prosecutor what crime there is and what to charge it under. And putting them all in one place solves that problem. So on behalf of the Hate Crimes Advisory Committee and on behalf of Rationality, I ask you to favorably report this bill. Thank you.
Let me ask, sir, why is this proposal so modest?
I think the decision, look, that we had an internal debate about that issue, obviously, and there's a lot more that could be done in this area, and probably should be done in this area. We thought that the best practice was to get the legislation, to get the laws consolidated and clear on their face, and then we can talk about further elements of hate crimes or enhanced penalties for hate crimes.
Yeah, I don't even know that it's enhanced penalties. I mean, frankly, I mean, if you go through this bill, and it's Friday afternoon, we're not going to go through it section by section, but, you know, there are certain instances I can pull out of here where what is alleged conduct, the crime just seems too high for me. There's or the penalty seems too high for the crime, right? There's other places where it's too low. And there's just not a consistency sort of across the statutes. And I guess my question sort of globally, and I've struggled with this bill for this exact reason, that you're asking the legislature essentially to bless this proposal and bless this consolidation, but it's a flawed bill in the sense that there doesn't seem to be a lot of thought put into why do we charge something as a C misdemeanor as opposed to something else as a C felony. I mean, is that a fair criticism, or do you disagree with that characterization?
I think it's a fair criticism of existing law in Connecticut.
Right, that's my point.
That's exactly right. And I do think that a more comprehensive effort to try to rationalize all that would make a lot of sense.
Okay.
But I don't think that's any reason to not consolidate provisions through the passage of Governor's Bill 90.
Well, I'm looking at the testimony from the Hospital Association on this bill. Have you had a chance to see that?
I saw that, yes, sir.
Okay. So, Section 11 of the bill. A person is guilty of hate crime for deprivation of somebody's civil rights, which deprivation of civil rights is what we use in the CHRO statutes to essentially say that we didn't make a certain accommodation for somebody. Person is guilty of a hate crime for deprivation of civil rights when such person subjects or cause to be subjected any person to a deprivation of rights, privileges, or immunities secured and protected by the Constitution or the laws of this state or the United States. So the way I read that, and maybe I'm reading it wrong, and I think the way the Hospital Association reads it is what right now would be sort of a classic CHRO complaint violation could be charged as a Class A misdemeanor. Is that the intent of this?
It is not the intent of this. I believe there's an implicit intent standard there. It's a criminal law that would involve a level of mens rea. And so the sort of strict liability that the Hospital Association posits there, I just don't think exists. Okay. The committee may want to clarify that, but there's no intent to create strict liability in that case.
Okay. No, I appreciate the effort that's gone into this. I appreciate the desire to consolidate these. I guess, whether we move this bill forward this year or not, I would certainly employ the Hate Crimes Commission to sharpen their pencils a little bit. And I don't mean to admonish you, but you're just sort of here. So this is more just kind of a global comment or struggle that I've had that, when we get these proposals in, say from the Sentencing Commission or others, it's helpful to have a little bit of, we know our penal code is inherently flawed. We know that if you go through it and you're like, well, why does something get charged as one crime versus something else? And I think this is a real opportunity for us to step back and say, okay, do we mean to charge this as a C misdemeanor as opposed to something else as a D felony, and why is there a gradation of penalties? And I would hope the commission sort of takes that opportunity to do that moving forward.
And I will take that message back, and I'm entirely in agreement with you, sir.
Thank you. Further questions or comments? If not, thanks for being with us.
Thank you very much. Have a good day.
All right, next we have Brian Carpet.
Good afternoon, gentlemen.
Good afternoon. Move the microphone closer to you.
I'm sorry. My name is Brian Carp, and I practice in the area of estate planning. And first, I would like to say that I opposed Bill 5266, not because it impacts the bottom line, but I think it's just not a good law. I think it creates a lot of problems, and I agree with Representative Fishbein. It solves a problem that doesn't exist. Currently, we have mechanisms. We have life estate deeds and joint tenancy, rights of survivorship, trusts. We have all sorts of vehicles to pass property on to avoid probate. And all of those are used with attorney and with guidance of legal counsel. I think it's a potential to be fraught with elder abuse, such as Representative Fishbein brought up and Judge Straight. And I would provide two examples of real-world color to it. I had one client who, his brother was able to get his mother to transfer through beneficiary designations about half of the estate, being the financial aspects, and took half the estate. I have little doubt that if he was able to do it with a deed, he would have done it with a house, which would have taken essentially all of the estate. It ended up being quite a bit of litigation. I have another one where very similar, where one of the kids, of 6 kids, really took advantage of her ailing father and was able to take a lot of the estate. So I think the potential for elder abuse is great. I think you're going to hear other testimony about this bill, and I don't want to just be repetitive, but one of the things that hasn't been addressed is the potential for Medicaid. If these beneficiaries are going to receive assets and they're on Medicaid, they're going to lose their benefits. And that may be because they don't know, and the transferor doesn't know what the impact that is going to be given. So really what's going to happen is the transfer might be benefited in this utopian idea, but it's going to impact beneficiaries, because even the explanations or the frequently asked questions in this bill, do I need to tell the beneficiaries about the TOD deed, says no, but it's recommended. Well, if somebody receives property, they're going to lose benefits. And Medicaid benefits, with nursing homes being $15,000 a month or more, that's potentially a $200,000 a year impact that the beneficiary didn't even know was coming. So I think there are a lot of issues. And finally, I would just say that it's been touted, oh, the simplicity, it's easy to do. Well, the problem is it's easy to do and people don't read. I see clients all the time that don't read retainer agreements. I go to rental agencies on cars. Nobody reads those things except lawyers. You can always tell the lawyers in the room because they read the front and the back of those rental car agreements. So my fear is this law, people are going to be entering into these deeds and writing these deeds without full recognition of what's going on, what the impact is, and what's happening, and the elder abuse. Happy to take questions.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? There are none. Thank you very much for joining us and providing us with your testimony.
Thank you, gentlemen.
Patrick Thomasewicz?
I have a very difficult last name, Senator Winfield.
Was Thomasewicz close?
My name is Attorney Pat Tomasowicz. Good afternoon, Senators. I'm here in support of the decision by Commissioner Shea of February 6, 2026, to award compensation to Mr. Stewart for a 31-day incarceration that was wrongful. Just very briefly, in December of 2013, Mr. Stewart was arrested for some misdemeanors. The DOC believed that he was still on parole. He wasn't. I had to dialogue with the DOC. It took 31 days to get him out. I filed my claim on a timely basis. I filed it under 4-165A. It worked its way through the Claims Commission. It took us 9 years. The claim was denied. It came to here. There was a resolution on April 16, 2024, vacating the decision. When it was vacated under 54-102 UU. I'm not sure what this committee knew as to what statute we were under. It was never filed under 54-102 UU, and we could not file a claim under 54-102 UU. The reason we could not file the claim under that statute is because he was incarcerated before there was even a conviction, number one, and number two, he was incarcerated for what was thought was a parole violation, when in fact he wasn't on parole any longer. So we couldn't meet the elements of the statute then, and we couldn't meet the elements of the statute when it was remanded to the Claims Commission. So during the Claims Commission hearing, I was asked candidly by Commissioner Shea, does 54-102 UU apply? Ethically, my only argument was no, it doesn't apply. We had filed our claim under 4-165A, seeking relief under 4-160, where the commissioner has an inherent equitable authority to allow a claim to proceed. I think when Commissioner Shea issued his award, his intention was not to derogate from the remand, where the remand was under 54-102 UU, his intention was to do the right thing. His intention was he recognized that there was a wrongful incarceration. There was no question that there was a wrongful incarceration. So he felt it was the right thing to award compensation. Subsequent conversations that I've had with Mr. Berry, Mr. Shea, including this morning, we vetted this. The state did argue at the time that we were locked in under 54-102 UU, that, to Senator Fishbein's questions, that 54-102 UU was the stricture under which the claim should have proceeded. Our argument was we were seeking equitable relief. The intent of the legislature was to authorize an award. We had filed under the inmate statute 4-165A, and Commissioner Shea awarded compensation. What I'm seeking here today is a new resolution authorizing the award under 4-165A, which was the statute that we originally proceeded under. During the 31 days that Mr. Stewart was incarcerated, it was not good. He was held at Hartford Correctional Center. He had to go through the medical unit first to try to convince people that the calculations by the DOC were incorrect. Eventually, he got a voice from a counselor. I got in touch with his counselor. It took him 31 days to get out. So I know as a fact that this committee always wants to do the right thing. I know that. And I know as a fact that this committee is interested in justice. I know that too. I know that the representatives of this committee are good men, and they want to do the right thing, because briefly I've had interchanges with Senator Winfield, Senator Fishbein, Representative Fishbein, and you guys have been a pleasure to deal with, not so much on this matter, but anything I've ever conferred with you. I know in your hearts you want to do the right thing. And I think the right thing, because there wasn't a question about the detainment, he shouldn't have been held that 31 days. That just because we're under the wrong statute to authorize relief should not rescind his award. It's a modest award. It was $500 a day. We're talking sum of $15,000 and change. And I think that there's an appropriate way to authorize this award. The intent of doing justice there, therefore, is preserved. And the appropriate way is just to say, look, he could never proceed under 54-102 UU. When Representative Fishbein, when I was in front of Commissioner Shea, I wasn't arguing for zero. I was asked ethically, does the elements of this statute apply? And I've spoke to Commissioner Shea this morning about this. I had to say no, because there wasn't a reversal, a vacator, there wasn't a dismissal. So I had to say no ethically, otherwise I would be misleading the commissioner. But our claim was never under 54-102 UU because he got detained before any conviction. The day of his arrest, they said, Stewart, you're on parole, you're going back. And he wasn't. His parole had expired. He should have been able to post bond on simple misdemeanor charges, which we ultimately did like 32, 33 days later. So I hope I'm being clear. I'm trying to be clear. And I'm hoping that we're not going to get into this complex debate under, it's only a 54-102 UU claim, so he should be denied. It really was filed under 4-165A, and relief can be authorized, I believe, under 4-160. I appreciate your time. I'm happy to entertain any questions.
Thank you, Attorney Tomaszewicz.
Yeah.
Representative Fishbein.
I love this process. I absolutely love this process.
Me too. Thank you for your preamble there.
I agree. I agree, because the problem is, maybe our fault. A condition precedent is that such person has been convicted by this state of one or more crimes and incarcerated. And you don't meet the condition precedent of conviction based upon the facts of this particular case. Right?
Representative, what I was arguing was this was a common law false imprisonment.
Yeah. And the intent of the underlying statute, but for the wrongful incarceration statute, individuals whose liberty had been taken away from them by malfeasance by the government, it would be a 1983 case in the federal court more than likely, and we, through the statute, attempt to take those cases away. You know, I had a case where a guy, they were scanning plates, and you know the police just screwed up and they picked up my guy, but I won't get into there's somebody with the same name and all this stuff, and there was, you know, and he was kept for a day in lockup, extradited from Wallingford to West Haven, and they had the wrong guy, and I brought a 1983 case, made some decent money on that one, but that would be the same thing, right? And you're looking to repair the harm here. So I totally understand how we got here now.
And let me, if I may, just to be hopefully resourceful, 54102 UUD1, there's no language that this august body has drafted saying it's the exclusive remedy. There's no, it's not an exclusive remedy statute. So, you know, alternatively, I just went under that inmate statute and by analogy argued a common law of false imprisonment. And I think it makes sense. I think it's rational. 1983 action, I think in my mind would be more appropriate. If I had a 5-year, 10-year, these are judgments that we make in the battlefield. And I thought that I had a pretty reasonable remedy for a 31-day wrongful detention. And I thought that statute, gave me the pathway because I could never use 102 UU. So that's why I went under 4-165A thinking I'm just going to have a jury trial in state court on it. That's what I thought. I didn't think it was a hard claim. When the DOC, a bench trial in state court, I should say, you don't get a jury trial. When the DOC came in, they apologized on the record. I mean, when we had a hearing in front of Commissioner Shea's predecessor, whose name now escapes me, I can't remember her name.
Scott.
Yeah, Christy Scott, lovely lady. But there wasn't a decision on that for like 5-6 years. I mean, she held the claim and just didn't adjudicate a decision on it. The specialist came in and apologized and on the record that I know Commissioner Shea heard. And I think when he, I think you need to know two things, right? I think number one, you need to know he denied it first, right? And just because I have a duty to be transparent, he denied it because he went on a property owner's property. He went on a front lawn and knocked on a door.
I remember all of
Yeah,
the
I don't
procedural
want to mislead anybody here as to the fact pattern. But ultimately, when he rendered the award after we had a caucus here when in April of 2024, his intention was just to carry out your award. And I'm hoping that you'll fix a wrong here and just authorize the award under 4-160.
Yeah, but for you coming here today, I will tell you, I was very concerned about where we were. So I thank you, I thank your client for authorizing you to be here today, because I think we'd be in a different place. So, I'm totally comfortable with where we are. So,
Thank you. Thank you, Representative Fishbein. Thank you, Senator Kissel and Senator Winfield and Representative Safstrom.
Thank you. Just to check, are there any further comments or questions from members of the committee? Further comments or questions? And I'd like to align myself with the last comments of Representative Fishbein. Thank you.
Thank you, Senator Winfield. I don't think Mr. Stewart will be speaking today.
Okay.
I mean, he's here, but I don't see a need for his speaking.
Yep.
But thank you and have a good day.
Next, we'll have Donna Civitello.
Okay. Good afternoon, esteemed members of the Judiciary Committee. Can you all hear me?
We can't see you. I don't know if you can activate.
True.
your
I'm
camera.
trying to, it appears,
go
here it
ahead
is.
and proceed.
Thank you. Thank you. There I am. Thank you. Thank you. My name is Donna Civitello. I'm testifying today in opposition to Raise Bill 5267. I've been practicing workers' compensation law in Connecticut for 40 years, and I feel lucky to live in this state where this legislature works hard to ease the rising costs of energy, housing, and food during these difficult times. So when I see a bill like Raise Bill 5267, I scratch my head and I say, what were its proponents thinking? To take total incapacity benefits away from seniors who have retired, many of whom live on fixed incomes. Well, they're clearly trying to shift a large part of their liability for compensable claims to the state, to municipalities, to the federal government, and ultimately to us, the taxpayers. In written testimony, I told you the story of my client, Mr. Malinowski, who retired after 40 years in order to care for his bedridden wife. Post-retirement, he became totally incapacitated due to a work injury which required surgery. He received total incapacity benefits for 4 months, less than 4 months, under the Workers' Compensation Act. And these benefits allowed him to pay for aides to care for his wife while he could not do so, aides he could not have afforded otherwise. So this was an unforeseen expense that was caused by the failure of the work-related knee replacement and his inability to do enough physical activities to be considered not totally disabled. So most cases are just like this, as work-related joint replacements, spinal fusions, other medical interventions fail over the years, and serious work-related diseases develop or progress. The financial effects of any new period of total incapacity to work become more challenging for those on fixed incomes. So why should we allow workers' comp insurers to be permitted to shift those costs to retirees and other societal safety networks? And speaking of cost shifting, 5267 is at cross purposes with LOC 876, a bill pending in the legislature right now. That bill is the result of more than 2 years of work to alleviate financial pressures on municipal pension and retirement systems. A linchpin of this bill is authorization for municipalities to reduce all pensions by the amount of total incapacity benefits paid under the Workers' Compensation Act during the period in which retirement benefits are paid. So if workers' comp insurers don't have to pay total incapacity benefits, then that financial relief for municipalities that would be provided under 876 just evaporates.
Your
So,
time has
yes,
elapsed.
I'm done, and I would urge this committee to reject this proposal.
Thank you.
Thank you for the opportunity to testify.
And thank you. Comment or question from members of the committee? Comment or question from members of the committee? There are none. I want to thank you for sticking around and providing us with your testimony today.
Thank you.
Next, we have Sachin Pandya. Hope I didn't butcher you too bad.
It's all right.
You may proceed.
Thank you. Good afternoon. My name is Sachin Pandya. I'm a law professor at the University of Connecticut, and I support SB 90. That's the bill that revises and consolidates the state's hate crime law. Just to reiterate what another speaker has already said, today Connecticut hate crime statutes are kind of a mess because they're scattered across 3 separate chapters of general statutes. They're inconsistent in what they require and who they protect, and none of them are actually called hate crimes. This bill tackles these problems. It aims to put almost all the hate crimes in one place, a hate crimes chapter in the penal code. LCO obviously knows that. If they don't, we should make that record now. Second, it makes the law clearer and more consistent. And for the first time, it actually calls them hate crimes. Who does that benefit? Victims, their communities, the police officers who investigate and enforce these laws, and the attorneys who are supposed to know when they apply and when they do not. But many of you already know this, including you, Representative Stafstrom, and you, Representative Fishbein, because SB 90 is almost identical to the version of HB 6872 that unanimously passed the House last session, that is with your votes in favor. For a refresher, you can take a look at the written testimony. Here, I'm going to focus on 2 features of the bill and then open it up for questions. First, this bill makes hate crime law more consistent and clear, more consistent in the protected social categories covered, more consistent in the required degree of illegal motivation, and it removes some serious legal ambiguities, such as the word maliciously. On this point, the public defenders have it dead wrong. If you want to know why, ask me in the Q&A. By the way, the Connecticut Hospital Association also has it wrong. Ask me why. Clarity in the law is critical for police and prosecutors to actually pursue hate crime charges when they're warranted, and for defense attorneys trying to defend and reliably advise their clients. Second, SB 90 is just a first step. This goes to your ambition point, Representative Staffstrom. Both last year and now, some folks have floated serious substantive changes quite sincerely. But rather than let a good bill like this one die like the last one, I suggest this instead. For some list of possible substantive changes to the hate crimes law, the ones that this committee thinks are worthy of attention, I would advise you to take up a sharpened pencil and write a letter asking the Hate Crime Advisory Council to evaluate each one of them and report back with recommendations before the start of the next legislative session. That's part of their job anyway, by statute. In the meantime, we need to act now by getting the existing hate crime law more consistent and consolidated, and that's why this bill deserves your support. Thank you.
Thank you. Let me just try it again. Sachin.
Sachin.
Got it. I think it's important to get people's names right. Okay. Comment or question from members of the committee. Representative Fishbein.
All right, I'll take the bait. Why are the public defenders wrong about malicious?
Okay, thank you very much. So let's talk about the law as it is and why maliciously generates this ambiguity. Of all the hate crime statutes in the general statutes, maliciously appears in only 2 of them, 53A 181J and 53A 181K. All the others have specific intent and the requisite legal motivation, but they don't use the word maliciously. Maliciously is, unlike intentionally, undefined in the penal code. So there's an ambiguity about what it means, and that ambiguity is exacerbated. In general parlance, maliciously typically refers to an unjustifiable motive. But in the context of hate crimes, it makes very little sense, because the statute already requires, in addition to specific intent, the unjustifiable motive of acting in whole or substantial part because of someone's race, religion, or other protected category. So ask yourself this question. If I were litigating a hate crime, and it was already stipulated that the person had specific intent, and it was already stipulated that they had the requisite motive based on race or religion, what is the additional item of evidence that a prosecutor would have to submit to satisfy the separate requirement that the conduct occur maliciously? That's a legal ambiguity. And I'm quite sure with a room full of lawyers, we can come up with a variety of different plausible glosses, but it's the ambiguity that's the mind killer here. It's the ambiguity that prosecutors understandably would want to avoid, and that's the ambiguity that by replacing maliciously with intentionally for those 2 statutes, making them more consistent with all the other statutes, constitutes a significant improvement on the current hate crime law.
Well, I thank you for that. Thank you, Mr. Chairman.
Thank you, Representative and Representative Staffstrom.
I wasn't going to take the bait, but I'll take the bait too.
Thank you.
So section 11.
Okay.
A person is guilty of a hate crime by deprivation of civil rights when such person subjects or causes to be subjected any person to the deprivation of any rights, privileges, or immunities secured by laws of this state, motivated in whole or substantial part by any protected social category.
Yeah, if I may.
Social category is age.
Yes. So
I fire someone from my law firm because I believe they're too old. Have I committed a hate crime?
Well, so let me go back a step. I think.
Well, let me answer my question.
Well, the question rests on a mistake. The mistake is that the Connecticut Hospital Association refers to Section 11 of the bill, but they got the numbering wrong. What they're really talking about are sections 15 and 16 of the bill, because in the content of their testimony, they're referring to a provision of the bill that imports existing law about public accommodations. Section 11 of the bill refers to the language you're talking about. So let's talk about what they intended to mean.
Right, I'm asking about my hypothetical, not the hospital
Okay, so,
association's
all right, so let's clarify that. Run your hypothetical again.
I fire someone because of their age.
Okay,
I believe they're too old to do the job, I fire them. Have I
Okay.
committed a hate crime?
under which provision?
Section 11 of the bill.
Okay, let's pull up section 11. What is the right, privilege, or immunity secured by the constitutional laws of the state that you're referring to?
Well, I think, you tell me, but I think this is the exact same language that we use in our CHRO statutes.
Yeah, that's right. And part of what's going on here is that this is importing what exists in our current statutes.
No, this is new language.
No, I disagree. The 46A chapter has this exact language. It is part of CHRO, but what this recognizes, that same provision also provides that a violation is a Class D misdemeanor. And so is a Class A misdemeanor, excuse me. And what it does is it ports that into the new hate crimes chapter. So if you're talking about an ambiguity, that's an ambiguity about existing law.
Not the way I see this, because it specifically says this is new language. I don't see where this is being transported over unless
Okay.
it's being dragged from, I mean, maybe the existing language is being dragged out of the CHRO statutes, but you're essentially putting it now into the penal code, and you're attaching a criminal offense to it, which is a Class A misdemeanor. So
No, that's incorrect. The criminal penalty already exists under current law. I can point you.
All right, so
yeah.
maybe you're right. So if you're right, then that I think goes to my broader problem with
Yeah.
this language, or this bill, which is, look, don't get me wrong, we shouldn't be firing people
Yeah,
based
yeah.
on their age. No doubt about it. We have a CHRO process, we have a civil legal system to address those types of instances, and we should address those. I don't think we should put somebody in jail for a year for committing that offense, which
Okay.
is what an A misdemeanor is. And so this goes back to my broader, I think, concern with this bill, which is that is admittedly flawed language. It looks like new language, and essentially what passing this bill is doing is asking the legislature to bless what is flawed language.
No, that's incorrect. Consolidation is not blessing. Consolidation is recognizing that to enforce existing law, police officers and attorneys need to have it be in one place and consistent. It doesn't mean that we agree that all of the provisions that are consolidated are good public policy.
But I don't want police officers enforcing this law. I don't want people being arrested for firing someone.
Okay. And so therefore, what exactly? You would rather continue the under-enforcement of all the hate crimes laws rather than consolidate? Is that the argument?
I don't think they're all being unenforced. I think what we should be looking at is where is the gradation of penalties?
Okay.
And my question is, and I asked this before, I'll ask it to you, why hasn't the Hate Crimes Commission started to look at that issue, or have they?
Because as the last legislative session demonstrated, the Hate Crimes Advisory Council had difficulty even passing a modest consolidation bill. I think the idea here is that we do this in sequence. Step one, look at everything we've got, put it into one place, make it rational, consistent not only with the council's view, but the Sentencing Commission, which issued a report which accords with the same sort of views. And then step two, much as I suggested, at this committee's behest or in some other way, put it on the council to come back for the long session and do these kinds of substantive issues that you're talking about. I think those are hard issues, and different stakeholders are going to have very different views. But I think part of the problem here is that if you want to do all that in a short session, that is effectively guaranteeing that the bill will die and nothing changes.
Yeah, fine, we can debate the process. I guess my question is, there was 7 months between when this bill did not get taken up in the Senate in June and when the bill was reintroduced in February. What work transpired in those 7 months?
With respect, you would know that better than I, because it was your committee that took up the bill, and it was your conversation on the House floor which resulted in amendments, which resulted in the bill that passed the House, which is almost identical to SB 90. So I don't know what the story is. I'd love to know. But the idea here is, you know, that's all water under the bridge. We can pass this bill now, which had consensus in the House anyway, and move the ball forward.
Yeah, okay, okay. Representative Fishbein.
Thank you, Mr. Chairman. I just, I see two things that I just need to join together.
Yep.
So in section 11, we have this concept of someone can be arrested and convicted of firing someone based upon their age as a Class A misdemeanor, and the representation that that is existing law and that you're consolidating. So if you could just identify where specifically that is an existing law?
Sure, of course. If you give me just a minute, I can pull it.
Absolutely.
Okay, 46A, 58A.
46A, 58A.
Sorry, it took me a while to pull it on the
No,
internet.
that's no problem. That's what this is for. Let me just pull this up. For some reason, that's not coming up. 56A. And then go to 56. Commission duties. And then, is it like a sub A? Okay, is it 46?
It's the first A, first paragraph in 46A, 58.
46A 58 or 46A 56?
Oh, I'm sorry, 46A, 58.
Okay, because
Yeah.
that's, and I think somebody up here was saying 46A 56.
No, 58.
Okay. So I'm going to 46A 58, which is nothing. Can you read me the language?
Yeah, sure. Subsection A, it shall be a discriminatory practice in violation of this section for any person to subject or cause to be subjected any other person to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or the laws of this state or of the United States on account of religion, national origin, alienage, color, race, sex, gender, identity or expression, sexual orientation, blindness, mental disability, physical disability, age, status as a veteran, or status as a victim of domestic violence.
Okay, so that's the violation. Oh, and then you're bringing me down to E.
Yeah, so E is where it sets forth the criminal penalties, except as provided under subdivision 2, and then there it talks about Class A misdemeanor.
Okay, so I guess to put the 2 points together, we see that in our CHRO statutes, because this is CHRO, right?
So yes, the CHRO has the authority under a subsequent section to enforce 46A, 58A civilly. But the statute itself also authorizes criminal prosecutions for violations of 46A, 58A.
Yeah, which CHRO does not have the ability to
Yeah,
prosecute.
they
so-
refer to a state's attorney if they so choose.
Yeah, I could see that. Okay, so that's the representation that the public policy we're joining together here.
Yeah.
Perhaps we need to look at that up here. So I thank you for bringing that to our
Yeah.
attention. So thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us.
Thank you.
John Anderson.
Good afternoon. Honorable members of the Judiciary Committee, my name is John Anderson. I'm the Chief Underwriting Officer for CADIC. That's a title insurance company that's headquartered in Rocky Hill. And I'm here in opposition, or speaking in opposition to House Bill 5266. So, CADIC is concerned that the passage of this bill will certainly encourage people to transfer what is their most valuable asset without the benefit of counsel, and of course without any probate oversight. And we've had a good deal of experience over the years. We've been doing business here for approximately 60 years, seeing what happens when people try to transfer deeds, prepare deeds, and prepare documents without having any knowledge of real property law or without having any experience in doing that kind of drafting. We know that that kind of situation can lead to increased errors in the deeds that are drafted, and that can lead to title defects, and ultimately that can cause an addition of costs and delays and litigation. As others have mentioned, or as other testimony may have mentioned, CADIC also agrees that this bill has the potential to possibly undermine the reliability of the land records, to the extent that there's nothing in this legislation, this proposed legislation, that requires the recording of any notification of the death of either a transferor or the intervening deaths of possibly designated beneficiaries. Also, we are concerned that because the expectation is that these types of deeds will not be executed under the advice of counsel and not executed in an attorney's office, that there is a great potential for having these deeds prepared in a way that will exploit the vulnerable population that we have when we see property owners that are in declining health. We can see that in that particular situation there is a potential for exploitation in the form of, well, anyway, to summarize, this is a situation where there are, as people have said, other alternatives that are out there to take care of situations. Very, very successful estate planning alternatives that we have in the state of Connecticut, including tenancies, joint tenancies with rights to survivorship, trusts, and also those situations where we could get a life estate deed.
Thank you.
All right.
Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us this afternoon.
All right, thank you.
Next, we have the last person on our list, which is Alex Taubes.
Good afternoon. My name is Alexander Taubes. I represent Charles Williams, Maceo Troy Streeter, and Dieter Tejada in 3 wrongful incarceration claims: House Joint Resolution number 5, Senate Joint Resolution number 7, and Senate Joint Resolution 8, respectively. I want to focus my time on a question I understand this committee is weighing: whether the pardons in Mr. Streeter's and Mr. Tejada's cases were granted on grounds consistent with innocence, as required by Section 54-102 UU. Let me start with SJ7, the Streeter claim. Commissioner Shea had before him sworn testimony under oath in which the state's only eyewitness in the Streeter case testified that Mr. Streeter is innocent and has always been innocent, and described in detail how Detectives Green and DeLulo, whose widow testified before this committee this morning, coerced through false identification and through threats and manufactured claims on Mr. Streeter's life. Assistant Attorney General Lisa Maria Priscino was present at that testimony and had the opportunity to cross-examine that witness at that time, chose not to do so. In addition, the commissioner received recantations from 3 other prosecution witnesses under oath, consistent alibi testimony from Reverend Boise Kimber across 2 trials, testimony from 2 scene witnesses confirming that Mr. Streeter was not present, and the complete absence of any physical evidence in Mr. Streeter's case. Commissioner Shea had all of this before him and held 2 evidentiary hearings and evaluated all of that before issuing his determination. He also had before him the testimony of chairman at the time of Mr. Streeter's pardon hearing, Carlton Giles, who submitted a sworn affidavit attached to my written testimony, confirming, quote, Mr. Streeter's claim of innocence was a ground for the board's decision, unquote. Now, of course, that is not a judicial finding of innocence. The Board of Pardons and Paroles does not make those, but it is a grounds consistent with innocence, which is what Section 54-1022 UU requires. The current chairperson of the board testified earlier today that the board does not consider innocence when granting pardons. That testimony is contradicted by a board hearing in September 2022, just 5 months after Mr. Streeter's pardon, in which board chair Jennifer Zaccanini asked my client repeatedly, "Don't you maintain you didn't commit this defense? Are you saying here today that you did not commit the offense?" The board then denied the application, with the chairperson stating, "I have trouble with the fact he can't acknowledge the offense." That is, my other client's pardon application was denied because he maintained his claim of innocence. The board plainly evaluates innocence claims and uses them to determine outcomes. But now consider Mr. Streeter's hearing. He maintained his innocence in his written application. He maintained it. Please approve Senate Joint Resolution 7 so that justice is not further delayed. Justice delayed is justice denied.
Thank you. Comments, questions from members of the committee? Comments, questions? Thank you for waiting all day. We really appreciate your testimony, and it helps to judge what's before us today. Thank you.
Thank you very much for the opportunity to speak.
All right. Those are all the folks we have signed up. I'll just take this chance to ask, is there anyone in the room who had not signed up? I forgot we don't know. Well, there is no one, so we're good. All right. We'll call this an end to the public hearing today, and we will return on Monday for more fun.